Thank you, ladies and gentlemen. May I invite Honorable Mr. Justice Rajendra Menon, the chairman of the panel discussion, to come to the dais. May I invite Mr. A.J. Jawad and Mrs. Uma Ramanathan, the panelists, to occupy their seats. So shall I start? Yes. Good morning once again, ladies and gentlemen. I am K.S. Sharma of Litigators Prime. I am an IIAM accredited mediator, a mediation advocate, and a certified commercial arbitrator. I welcome all of you to this beautiful event to celebrate the completion of 3 years of service by E-Mediation writings, on which occasion we have organized a Mediators Parliament. You may be wondering why we are starting with a panel discussion pushing behind the inaugural ceremony. One of the differences between litigation and mediation is that in litigation and in the judiciary, we go by precedents, whereas in mediation, we don't go by precedents. In mediation, we ask why not more than why. So why not start with a discussion on an important subject when our minds are fresh and receptive in the morning? More so because the topic of this panel discussion is of great importance, which is institutional mediation. Thank you. Before we proceed to the panel discussion, I think that it is worth taking a few minutes to explain what is mediation, because there are a few in this audience who are not mediators. At the same time, this august assembly comprises of great experts in mediation. I request all of them to forgive me for explaining the basics for the benefit of the minority. There are a few types of mediation. However, when we just say mediation, we generally mean facilitative mediation, which is facilitated or assisted negotiation. And negotiation, as you know, is defined as communication for agreement. Therefore, mediation or facilitative mediation is communication for agreement. A mediator is a third-party neutral who converts the dispute into a mutual problem to be solved by both the parties. At the heart of facilitative mediation is principled negotiation, which was developed by the Harvard Negotiation Project in the 1980s. The 4 prescriptions of principled negotiation are: number 1, separate people from the problem. Be soft on the person and hard on the problem. Number 2, shift the focus to interest from position. Focus on interest and not on position. Number 3, invent options for mutual gain. And 4, use objective criteria. There is dispute because people take positions. Position is what people say they want, whereas interest is why they want what they want. 2 students were fighting in a library. The librarian came over there and asked what was the problem. The first student said that he wanted the window open, whereas the second student wanted the window closed. So she asked the first student, why do you want the window open? He said, I want fresh air. She asked the second student, why do you want the window closed? He said, it is creating draft, so I am not able to work. She then asked both of them, is there a way by which we can get fresh air and at the same time draft will not be created? Then one of the students said, I have an idea. He went to the neighboring room where there was a huge window. He opened it, and as a result, they got fresh air without creating a draft on the table. In this case, the librarian played the role of a mediator. She enabled the students to shift the focus from position to interest. The position was window should be closed. The position was window should be open. The interest was that it should not create interest. It should not create draft. We should at the same time get fresh air. By asking whether they could get fresh air without creating draft, the librarian made the students to come out with an option for mutual gain. William Urey explains this through a story which is famously told in the Middle East. A herdsman died, leaving a will saying that he had 17 camels, which should be divided amongst the 3 sons in this manner. The eldest son should get half the number of camels, the second son should get 1/3 number of the camels, and the third son should get 1/9 number of the camels, and the camels should not be sold or killed. Now 17 is not divisible by 3, it is not divisible by 2, it is not divisible by 3, it is not divisible by 9. So they went to a wise old woman of that village and showed her the will, and after reading it she said, you wait, and she brought one of her camels and said, now you take this camel and solve your problem. 17 plus 1 became 18, so 18 divided by 2 is 9, the eldest son got 9 camels, divided by 3 is 6, the second son got 6 camels, and divided by 9 is 2, the third son got 2 camels. 9 plus 6 is equal to 15, plus 2 is equal to 17. The camel which the wise old woman gave back to her. So the mediator is the 18th camel who goes inside, solves the problem, and comes out. We will now start the panel discussion, which Honorable Mr. Justice Rajendra Menon, who is the chairman of the Armed Forces Tribunal, will be conducting. A product of Christ Church Boys Senior Secondary School, Government Science College, Jabalpur, and NES College, Jabalpur, Justice Menon had an illustrious career as an advocate at the High Court of Madhya Pradesh from 1981 to 2002, when he was appointed as the additional judge to the bench of the Madhya Pradesh High Court. Later, he became a permanent judge. He served as the Welfare Commissioner of the Bhopal Gas Victims Compensation Commission from 2010 to 2015. He served as the Chief Justice of the High Court of Patna and then as the Chief Justice of Delhi. What I have presented to you is only a tip of the iceberg of his profile due to the paucity of time. I request Honorable Mr. Justice Rajendra Menon to give his chairman's remarks.
Good morning to all, and as I said last evening on the occasion of the 3rd birthday of EMW, all are here to participate in this Parliament on mediation. When I speak of mediation, I always remind my audience, and many here know, that I am neither a trained mediator nor a professional mediator. Whatever I know about mediation is, while administering the process of mediation in the high courts, 3 high courts, right from 2007 onwards, and whatever I have learned about mediation is from my friend Dr. Sudhir Jain, hearing him, my friend Jawad, and all of you. So, I'll not say much on mediation because Jawad ji is here, Madam Uma is here, you may have queries, and I'm told 2 of the experts Mr. Chandok and Anurup Omkar would be joining us online to answer your queries. Mediation, according to me, with my experience in judicial administration for the last 22 years and as a lawyer for more than 21 years, it is the requirement of the day. Future of litigation in the courts has to be resolved by the alternate dispute resolution system, and in my opinion, and which I feel most of you here would agree, is mediation. The mediation bill is in the process. It was presented in the Parliament. It has gone back to the Select Committee of the Parliament for further discussion. And the Attorney General, I am told, is working on it. And very soon, in the monsoon session, it would come back and we would be having the statute in place for mediation. And when the statute comes into place, the concept of mediation will change. If you go through the proposed mediation bill, you will find that institutional mediation has been specifically mentioned in the bill. And in the classes of mediation indicated in the bill, you will find that in the object of mediation itself, the bill says, the object of the bill is to promote, encourage, facilitate mediation, and it says, especially institutional mediation. And that is why, when Dr. Sharma said it's an important subject, that is because the object of the bill itself is to encourage institutional mediation. And if you go through the salient features of the bill, you will find that it has, in its present form, about 65 clauses and 10 schedules, and extensively covers various areas, and importance is given in various places of the bill to institutional mediation. The government has been given the power to frame bills and also specifically to frame rules for the purpose of institutional mediation. If you find the classes of cases which have been incorporated in the bill, you will find that it speaks about mediation can be conducted by a mediator as per, and it speaks about 4 or 5 clauses. It says, first is choice of the parties, second is court annex mediation centers, third is mediators empaneled by authority constituted under the Legal Service Authorities Act, and the fourth is empanelment of mediators by the service providers. Now, if you go through all these 4 clauses, except in the case where the mediator is appointed by choice of the parties, in all other the 3 clauses, mediation is by an institution provided in the system. So that is why when the organizers chose this subject, they, I think, were aware of the importance of mediation which would be there in the coming days. And therefore, let us ponder about the requirement of mediation with experts here. As far as my experience with mediation is concerned, in way back 2005-2006, when we introduced mediation in the judicial system, it was purely institutional and court-annexed mediation. And when the mediation training started, trainings were given mostly to judicial officers and advocates practicing in the court. The consequence of that, I could see, was a judicial officer was more interested in getting his case disposed, because in conducting a mediation and getting a case disposed, he did not get any unit. And therefore, they would finish their board at 3:30, 4 o'clock, sit for mediation as a formality, and the mediation would be over in no time. From there we started, and today we are in an age where mediation has become order of the day in most of the litigations we have these days. And COVID was the period when mediation took a totally different form. Online mediation came, and now with the mediation bill to come, institutional mediation, as I said, would become an important facet of mediation. So, I have just come here to introduce the subject and to learn from the experts who are on the dais and who will be joining us how to go about mediation. I can say one thing with all humility on my side, that I love mediation, and I come to all the programs conducted by EMW because I found that they are doing something which is required in the coming days. I remember the day when EMW started. It started as a magazine to circulate articles on mediation amongst the fraternity of mediators, and today they have grown into a pan-India institution where they have representatives from all the states, from Kerala to Jammu Kashmir and from Guwahati to Jodhpur. So that is what BMW has done, and I feel proud to be associated with that. Thank you all for giving me an opportunity to express my words. I deliberately did not say much on institutional mediation for two reasons. One, I may not be able to come out with the correct position on that. And the second one is, I have certain issues with institutional mediation which were there in the past. The bill is in the offering, and I think it would be people like Jawad sir who would be more vocal on it, and I would simply say as a member sitting with him in the bench that I agree with whatever you say. Thank you very much. Jai Hind.
Thank you, Honorable Mr. Justice Rajendra Menon. As I was listening to you, I could see that we have come this far in mediation in the country because of leaders like you who have been working with so much enthusiasm for the last about 2 decades. Thank you, sir. Thank you. The first panelist to speak is Mr. A.J. Jawad, who is an accredited digital dispute resolution specialist with ADR ODR International UK. He is partner and head of ADR Services, KD Lex Chambers LLP, Gurgaon, Delhi. He is a mediator and mediation trainer working as global faculty for ADR ODR International UK. Senior mediator trainer for the Mediation and Conciliation Project Committee, MCPC, of the Supreme Court of India, and the Tamil Nadu Mediation and Conciliation Center at the High Court of Madras. Jawad's experience includes conducting basic and advanced training in mediation, as well as training the trainers for MCPC, TNMCC, and civil commercial mediation training courses in the universities in the UK and in India. He is a global faculty for ADR ODR International UK, co-founder and former trustee of the Foundation for Comprehensive Dispute Resolution based out of Chennai. He has more than 15 years of experience in conducting civil, commercial, and matrimonial mediations. Jawad is empaneled as India's specialist mediator with the Singapore International Mediation Center and the Bombay Chamber of Commerce, and as arbitrator with the Madras High Court Arbitration Center and the Indo-German Chamber of Commerce. Jawad is a guest faculty for the master's degree program in mediation at the Maharashtra National Law University. He is a faculty in the National Judicial Academy. What a mind-boggling career in mediation. Even then, I am not frightened because as a moderator, I have to only ask questions to Jawad and he cannot ask me any question. Before I initiate the discussion with Jawad, I must confess, Mr. Chairman, sir, that I am going to play the devil's advocate and make Jawad to lose his patience. Jawad, a few of the salient features of mediation are innovation, creativity, and ingenuity. Freedom is a prerequisite for innovation and creativity. Innovation happens where the mind is without fear and the head is held high, where words come out from the depth of truths, where the mind is led forward into ever-widening thought and action. A mediator is a liberated person, willing to break the rules. I repeat, willing to break the rules, who asks why not and does not look for any precedents to do anything. I fear that all I said now will be hampered in institutional mediation because the institution may make the mediator a caged parrot. As a young barrister practicing in South Africa, Mahatma Gandhi had brought about private compromises of hundreds of cases. Prophet Muhammad resolved a dispute between two tribal groups who were at loggerheads with each other by suggesting an innovative solution which benefited both the groups. The Prophet converted the two warring groups into friends. There was spontaneity in the actions of the Mahatma and the Prophet, a spontaneity born out of their love towards everyone. I believe that had they been confined to the rules of a particular institution, they would not have been this effective or successful. The rules of an institution are likely to make the whole process mundane, bureaucratic, and unromantic. The focus will shift to being consistent with the rules of the institutions and to play always very safe, which will result in mediocrity because, as Oscar Wilde had said, consistency is the last refuge of the unimaginative. And lastly, liberty of thought and action is the only condition of life, of growth, of well-being. Where it does not exist, the man, the race, the nation must go down. Jawad, can we allow mediation to be drowned by institutional bureaucracy dominated by armchair theoreticians? Over to you, Jawad.
No, actually I was, as the question went on, I was almost breaking into a sweat. I mean, I am breaking into a sweat. So I thought it was the heat. Then I realized it was the heat of the question. So, so Sharma sir, I think you gave some wonderful examples of Mahatma Gandhi and Prophet Muhammad and Swami Vivekananda. Now, they were all people blessed with infinite wisdom. The problem here is that there is also a Jawad who aspires to be a mediator, who may not, who definitely does not have the wisdom of Mahatma Gandhi or Prophet Muhammad or Vivekananda. The question is, if you want to professionalize, because mediation we are talking about now is not just the kind of mediation that Mahatma Gandhi did or Prophet Muhammad did, but it is mediation which is going to be working at a commercial level, at a professional level. So we are talking about professionalizing mediation. So when we are talking about professionalizing mediation, I think there are two things that become very important. Number one is the credibility, and number two is accountability. Now you take any profession, whether it is the legal profession, whether it's the medical profession, or any other profession, there is an element of credibility and accountability that becomes important. Now, one of my favorite mantras, and I don't have a copyright on it, please feel free to use it if it appeals to you, is mediation is the healing process and mediator is a healer. Now, when we are talking about the kind of emotional healing that we would love to see in a mediation, which may not always happen though, which I can definitely vouch for from past experience, we are talking about handling people's problems. We are talking about dealing with people's problems and helping them to deal with it. So basically mediators require three kinds of skills, because you gave a very beautiful example of the window to be left open or closed. Now the difference here is what a judge would do and what a mediator would do. A judge would probably evaluate whose is the better claim and give a direction that the window should be kept open or kept shut. But a mediator will ask that question, why is this necessary for you? And help the parties to decide how they want to keep the window, right? Or which window to open or which window to close. So therefore what we see here is that there are three kinds of skills that mediators require. So I categorize them as 3 Ps. Again, this is not an original idea, I read it somewhere. So mediators need to possess people skills. So the ability to handle people, to handle emotions, to be able to move people beyond their emotions, beyond their positions. Number 2, process skills. How do you conduct the process? So every profession, like for example, if you take a surgeon, now to perform the surgery, there are certain protocols that need to be followed, right? Now you have to observe those protocols, and in the course of the surgery, you may have to be creative. You may have to make use of your own ingenuity, your own skill, to do things that might be required to save the patient's life. Similarly, a mediator will be called upon to follow certain protocols. Like for example, there are certain ethical principles which underlie mediation. Most important is self-determination. So what really distinguishes mediation from any other dispute resolution processes? In every other dispute resolution process, a third person tells the disputing parties what to do. But the mediator does not do that. The mediator asks them, what would you like to do? So this is the essential difference. So self-determination. So the parties determine how they want to resolve this. So that is one very ethical principle. Confidentiality is one very important ethical principle. Absence of conflict of interest between the mediator and the parties. That is a very an ethical principle that can never be compromised. So when you talk about these protocols that need to be followed, here is where institutions can play a very important role. We already have institutional mediation. Today the most popular mediation is court-annexed mediation. And that is institutional mediation, because the courts as an institution are offering this option to the parties, saying that look, here is something that you can do to help you to resolve your disputes in a quicker way and in a more efficient way. And besides that, apart from that, you have the right to decide how you want to resolve it. So now when we talk of institutions, what we are talking about is some kind of, one, it gives credibility. Like I can be an independent medical practitioner, I can be a doctor who has my own clinic, right? I can run my own clinic and look after my patients. But when I'm part of a hospital, now the quality of my service changes, I'm more accountable, and I also have more facilities at my command. And for example, if you take a hospital, there are different verticals there. Each hospital might have a cardiology section, it might have an orthopedic section, it might have a section that deals with complications arising from diabetes. Now in mediation also we'll be dealing with different kinds of problems. Now when we are talking about different kinds of problems, you need different kinds of people who will be able to deal with those problems, who have some background knowledge. I'm not talking here about domain expertise. What is more important in mediation is the process expertise, but some amount of domain knowledge is always helpful. So when you have these verticals, see, institutionalizing mediation, what will happen is there are two kinds of institutions that we contemplate. One is the institutions that are more of regulatory bodies, that would be prescribing what kind of qualification, what kind of training is required, and who will also be sort of disciplinary bodies where complaints can be made against mediators who are registered with them if there is any misconduct or any. So that becomes important. Number two is institutions that would be service providers, that would be conducting training for mediators, that would be offering mediation services, who will be having a panel of mediators. So looking at it from these perspectives, ultimately when we talk about who are the people who are going to be most affected by this, they are the stakeholders, the litigant public, the people who are having disputes. Now they are going to be coming to mediators. So when you have an institution, it has more credibility and it has more, what should I say, an accountability. People feel more confident in dealing with institutions. So when we talk about these institutions, I don't think it in any way that is going to kill the creativity of the mediators. Because as you're doing a mediation, now how do you have to handle a particular problem? How do you have to handle a particularly difficult party? What kind of skills are you going to use? How innovative are you going to be there? How are you going to brainstorm and sit with the parties and brainstorm different options? Now this is where the creativity of the mediator plays a role. And that has nothing to do with the institution with which you may be associated. The institution is going to lay down the broad rules which you need to follow, the protocols, the ethical values that you need to adhere to. And they will give confidence to people that, okay, this person belongs to this institution and therefore I can be assured that the quality of service will be good. So that is how I look at it, sir. So I don't think in any way that institutionalizing mediation is going to curtail or curb or affect the creativity and ingenuity of the mediator in any manner whatsoever. So I hope I have answered the question. Now one example before us is arbitration. A huge country like India, for example, we don't have as many credible arbitral institutions as you would like to have. And today we are not the hub of arbitration. A small country like Singapore is able to dominate. Okay, so they are leading in arbitration. Why? Because we did not focus on institutionalizing arbitration. Arbitration continues to be an ad hoc process in India. So this is where the challenges come, and that is why it's important that we focus on establishing those institutions and institutionalizing mediation so that there will be more credibility, more accountability, and more trust from the stakeholders. Thank you. I hope I haven't taken too much time.
Congratulations, Jawad. That was a beautiful rejoinder. I accept your defeat. Swami Vivekananda said, there is no human action to which some evil does not cling to. And hence, we should engage in such actions which bring the maximum of good and the minimum of evil. Perhaps in institutional mediation, there is evil, but it is only minimum and the maximum is good. Thank you. The next panelist is Mrs. Uma Ramanathan. Uma, who is a graduate in English literature and law, has undergone extensive training in mediation in different institutions. She has been a mediation trainer since 2008 and has conducted training programs, including for different groups in different parts of the country, including judges. She was member of the panel of the Supreme Court of India, which collated the training manual. She is the managing trustee of the Foundation for Comprehensive Dispute Resolution and had contributed articles to many professional journals. I have been many times amazed by her in-depth knowledge and understanding of the human mind. She is philosophical, rather spiritual in her outlook. And she is a continuous learner. Even this morning she was telling me that she is going to undergo a training program in human psychology, a very expensive training program. Uma will now speak on the need for best practices and standards in professionalizing mediation, which Jawad said is the reason for institutionalizing mediation. Perhaps if Uma wants, she may try to convince Jawad that even without institution, it can be professionalized. But anyway, I will not be here at that time. I apologize to you, Mr. Chairman, sir, and to the panelists and the audience that I need to leave now for a pressing work related to this program. Jawad has kindly accepted my request to moderate the discussion further. Thank you, and over to Uma.
Good morning, everyone. Honorable Mr. Rajendra Mem, all of you gathered here, I don't want to individually name everyone because that will take a long time. And I'm really happy to see all old faces. Partly because of COVID and partly because of other reasons, I haven't been traveling or meeting other people, and I saw this as an opportunity. But when Mr. Sharma said this is the topic, I thought, my God, I have to study now. I can't just rush in here. And after coming here, and when Justice Rajendra Menon said that he's not going to say anything about it, I thought maybe he's testing us. Oh, am I here for an examination? And then, of course, as usual, Jawad has said a lot, and it's a hard act to follow. But I'd just like to say a few things. Last year, I had an opportunity to do a training for ADBI Tokyo. And some of the students from Shastra University were coordinating with me. And when I was discussing with them about the policy paper they wanted, a second-year law student, she came up to me and said, Madam, has anyone thought about the vulnerability of all people involved? And that was for the first time I started thinking about it. I had never thought about the vulnerability. And I think that is the basis for the need for professionalizing or institutionalization of mediation. Now, when I was thinking about this topic, I also came across a definition. Of course, we all have seen different definitions of mediation. But this particular one by Enosh, Folger, and Bush says that mediation is a social process where a third party helps parties in conflict to understand their situation and to decide on doing anything if they want to do, and that the third party would only be a guide to them. Now, this was totally a different definition from what I have seen so far, and that made me think about saying help to understand, decide if anything they want to do. So the whole thing is totally open. So this third party is there only as a focus light on the situation, on the needs of the parties. So when I was thinking about this vulnerability and this focus, I was also forced to think about the SWOT analysis of mediation. We've always gone through what are the strengths, weaknesses, opportunities, and threats. We always talk about flexibility, as Mr. Sharma was also talking. We were talking about whether it would curb creativity. But then I was thinking that it's not that we are pitching mediation as something which is good for people now. We have already done enough to sell mediation. But today we are talking about the efficacy of mediation and the commerce involved in it, because it's gone a stage beyond that. Now, Professor Bush also discusses in a particular, where they spoke about institutionalization of arbitration. He says, see, we've always thought about what the judges would do or the courts would do about all these processes. Have we thought about what mediators would do with the process, or what are they doing with the process? So it's important to address what the mediators are doing. If we are doing that, then we have to think about, it's not just the time and cost involved in dispute resolution. We also have to think about what kind of training we have, what kind of process is being done, and especially when this definition talks about a social process. So it's not just about two people having, or two or more people having a problem and somebody resolving it. It is how it is affecting the society at large. Now, when we say society, what is a society? It's not just a group of people. It is also the concepts that make it cohesive. So there is shall I say, a pillar which supports it is social. For a society is what is cultural, what is education, what is judicial, what is the well-being of the group as such. So when we think of that, then it is very important. As Jawad was saying, he was talking about process skills and people skills. You know, that is what makes it a society. But what is more important is what I would, I have a favorite way of putting an acronym. I put it together as PEG, P-E-G. Now, P is for polity. We need an identity now. We need something which is, although we refer to it as alternative or appropriate or something else, have we thought about mediation as a framework of resolution, as a process which disputants can use to benefit from? So there must be something where it has an identity, there must be resources connected to it, there must be some sort of a hierarchy. So having a polity in place is very, very important. And when I was thinking about that, okay, we have a process, we have people involved, it's a social process. Then there is also efficacy which is involved. That is where training comes in. But in that efficacy, it has also to be ethical. So it has to be an ethical efficiency. Then when we talk about ethical efficiency, we also have to think about some correctional structures to be put in, framework to be put in, because we need to handle the integrity of the process. So there has to be some sort of governance. So we need regulations also for this. So when we talk about a process that is evolving, a process that is going to help people or it brings value to people, it's not just creating a value. Of course, we say in mediation that people come in claiming value, we create value there. Is that enough just to create value? We need to do something more about it. We need to optimize that value. We need to, pitch it in the place where there is an exchange of value and there is prioritizing also. So, if we are thinking about value, if we are thinking about this governance, we are thinking about correctional methods, it is important to understand that today mediation is a profession. Whether it is ODR or personal, or it may take another form later. But what we have to understand is that, I think it was Professor Riskin who said, I'm not very sure, but I think it was Professor Riskin who said, that when a person goes to a lawyer with a problem, what was a human problem becomes a legal problem. It is necessary for us to shift it back as a human problem. So when we talk about professionalization or about institutionalization, what we have to understand today is that we have to be careful that we are not impinging on the humane aspect of the problem. We are also providing a space for it to develop as a relational issue where people can understand what is the importance of that relationship and develop on it. There is chance to be creative and to optimize the solutions and to understand, as they said in this definition, whether they want to do anything with it or not. So it has to be a governance which helps to keep it in a groove where integrity is assured. People look on it as having an identity on which they can trust and they can use the process. They can rely on it. Because today the problem is, of course, after the legislation comes, it may be a different view. But today, people are still hesitant to use it because they say, what is the authority? What is it we can bank on for enforcement? How do we, even if we come to an agreement, how do we think that this will be accepted? So I think the main factors that we have to think about today, whether we are thinking about professionalization or as a next step institutionalization, we have to think about competence first. So that starts with training. Is this training enough? The kind of training that we are doing. I was sharing with Jawad once. I read a paper, thesis paper from a student, PhD student in University of Maryland, where he says this 40 hours training, we talk so much about 40 hours training. And he says that 40 hours training came about because one particular hotel was prepared to offer a rate which was nice for them. And that's how they started this 40 hours training. And I think we have gone much beyond that. Today we know, especially in US, a lot of psychologists are mediators. They don't know anything about law, but they are mediators annexed to the court. And as Jawad was saying, it has already been institutionalized because it is part of the court program. So as Professor Bush says, are we still thinking about the process as aligned only with the court? Any training that also has to benefit the court? Any training or any practice that only looks at the outcome to say that the dispute is resolved? Or are we looking at resolving the crux of the issue or understanding the issue? So again, training has to focus on that. We have to understand more of behavior. And I was telling Mr. Sharma, I decided to go for this particular course which is starting on 17th June. It's an online course, but I decided to go for it because it talks more about understanding yourself. So then you, as a mediator, only then you will be able to understand others. And especially today, psychodrama is being propagated as a very important facet of training also. So I think we need more discussions. This is just the beginning. And I think maybe we have kick-started something which would give food for thought for everyone. But I think we need to expand on how we are doing the training, or an institution or somebody who will be responsible to see that the right thing is done. Or if something is not done properly, at least to see that people are put on the right track. And towards that, institutionalization becomes important. These were just a few of the thoughts that I had in my mind, and I hope I have given you something to think about. Thank you for this opportunity.
So I've just removed the hat of the panelist and I'm now wearing the hat of the moderator. So I'm really privileged today to be welcoming Mr. Chandyok sir, who's going to be joining us online. Mr. Chandyok, I think almost everyone in this room knows him. For those who don't know him, not to say that you're living under the rock, but still, he's a practicing senior advocate in Delhi. He's a qualified mediator and trainer for mediators. He is accredited by CIMI, Singapore, and Strauss Institute for Dispute Resolution, Pepperdine University, USA. International Honorary Senior Fellow, Strauss Institute for Dispute Resolution, Pepperdine University. Arbitrator, Singapore International Arbitration Center. Member of the Russian Center for Dispute Resolution of the BRICS Forum. Member London Court of International Arbitration, Member Indian Council of Arbitration, President Madhyam International Council for Conflict Resolution, President INSOL India, former Additional Solicitor General of India, former Principal Counsel European Union Commission, was President of the Delhi High Court Bar Association for 6 terms, President-elect the Bar Association of India. I think that one qualification, President of Delhi Bar Association for 6 terms, should speak volumes about the kind of popularity that he enjoys. Was a member of ICC arbitral tribunals for international arbitration at various places, represented the Indian government in the Enron arbitration in London, appeared before various arbitral tribunals of International Chamber of Commerce at various places, appeared in many commercial arbitrations in India, was a member of the Overseeing Committee of Samadhan, the Delhi High Court Mediation Center, since its inception till 2014, and was actively involved with the mediation movement in Delhi, was also a founding member of the Association of Indian Mediators and was its vice president till 2016 when it moved from Delhi. He participated in several mediation and arbitration focused conferences, seminars and discussions, actively involved in ADR for over 3 decades now, with the establishments of Samadhan and Madhyam International Council for Conflict Resolution. Apart from conducting institutionalized mediation and arbitration, enormous... Did you say something, sir? Okay, he's joined online. Okay, and wonderful. So he was invited as an expert on Indian laws by various courts, tribunals of the United States, United Kingdom, and Australia. He has received many awards in recognition, including the leader in... Who's... Okay. It's like suddenly God speaking to you, you know. Leader of the Bar Award 2007 from the Bar Council of Delhi. First time the Bar Council had conferred this award. The National Law Day Award 2006 from the Prime Minister of India for the contribution made in the practice of civil law. The award for rendering meritorious legal services from Delhi Citizens Forum for Civil Rights in 2002. The Outstanding Jurist 2000 Award by J.N. Kaushal Jurisprudence Center, New Delhi. Sikh of the Year 2010 Award from Sikh Forum International, London, UK. He was also awarded 2 doctorate degrees honoris causa. He has traveled extensively in India and abroad, enjoys photography, classical Indian music and films. So, well, so you see now, when we are talking about institutional mediation, we have a one-man institution with us today. So thank you very much for joining us, Chandyok sir, and it's an honor and privilege to have you here. Now with all these things that you have done, and I don't know whether we can even match up to a fraction of what your achievements are, and being instrumental in setting up Samadhan, the Delhi High Court Mediation Center, and also being one of the founders of Madhyam. So how do you see the future of institutional mediation in India? And do you think we need a roadmap for it, and how do we take it forward? and make it really happen so that mediation becomes a mainstream dispute resolution process instead of being, treated as a poorer cousin of arbitration.
started deciding so many stuff. I mean, where could I regularly even provide such a situation in mediation? Nobody can do so. But I'm looking at an institution surely created, an institution limited, A, by mediators themselves to formulate what they should do. And I know some people will be legislators, some people will here to join others. Maybe the view that self-determination with loyalty
So far, uh, I'm sure Sharmaji will be very happy because he said he was playing the devil's advocate. So obviously he believes in institutional mediation, and he was just challenging us to find out what exactly it's all about, so that we have a clear understanding. And I think both Uma and Chandyok sir have very clearly explained the importance of institutionalizing mediation from the perspective of credibility as well as accountability. The next speaker we have is Anurup Omkar. He and his wife Kritika Krishnamurthy have been in the forefront of the mediation movement for a very long time, and they have authored some books also. So Anurup is an experienced attorney with a demonstrated history of working in the legal services of industry. He is skilled in negotiation, legal writing, corporate law, banking and finance, fintech, payment and settlement systems, insolvency, private equity, mergers and acquisitions, international trade investment law, and alternative dispute resolution. He is a strong professional with a BCom LLB focused in law from Gujarat National Law University. He is the founding partner of AK and Partners, which is Kritika and he are the founding partners of that. He is the honorary director of Bridge Policy Think Tank. So Anurup, thanks a lot for joining. I know you're traveling and the timings are very odd for you, but nevertheless you have taken time off to join us. Thank you so much. So Anurup, I would, if you can speak on, because we were all talking so far about institutionalizing mediation. So obviously when you're talking about institutions, we need some SOPs, right? So what are these SOPs which will ensure the credibility of these institutions? So how do we ensure the credibility of these institutions? And see, sometimes what happens is the founders become the institutions become so identified with the founders that once the founder is not there, the institution collapses. So how do we make the institutions outlive the founders? At least make those institutions immortal. How do we do that? I think I can't think of any better person to speak about this than you, Anurup. Thank you.
Thank you. competition centers for the public sector and commerce and industry. So let me just give you a forethought why we decided to work in public sector and commerce and industry to build Center for Mediation Qualification. Number one, with I had the opportunity to attend one of the conferences in knowledge area, as well as that the organization, we were non-for-profit organization, we were industry body for the most commercial and profitable organizations in the country, stands strong for 1 years of existence. So that private equity that the organization can stand for 1 year, that would be non-profitable in nature for the most profitable sector, it has some basic values and ethos based on which they have been able to develop the standard operating procedure and they stand and they are alive for a time frame of 180 years. Given that, it is up to the management and as we said that you guys, keep a point of contact to the corporate houses, you should explore setting up a dispute resolution center because we are sure most of your members want to use mediation as a service and hats off to them. They appreciate our request and they say yes, we are willing to explore how to set up a dispute mediation setup. But prior to that, can you and your policy team can tell us whether you are even trained to prepare a standard operating procedure for the organization. That took us, back and we were to learn, how to interpret laws, how to, do advocacy about mediation, how to speak about mediation or mediate or train. But this is something, either none of the trainings are taught us, either this is something, we know how to do. And that's where they granted, the former Director General who is again, famous alumni of IIT and IIT of India. And he was responsible for laying standard operating procedures in the Tata Group. And there is something called tax which we gave in our bureaucracy. But Tata has its own bureaucratic system called Tata Executive Service, which most of the Tata subsidiaries companies say that without tax in existence, it is impossible for all of us to coexist together under the plan for Tata. So he was a guy from tax who was responsible for laying down standard operating procedures for the entire Tata group. And that's where the first thing he told us that we began interacting, Anu and Ritika, we ensure classes don't do on your feet. So how do we do that? What is the trying to say? What we did is, work with build an organization, move on, and fix or without you, the organization should survive. And that is what I personally believe, not getting into the nitty-gritty of standard operating procedure, because it will be doing lecture that because it can be a long time to be said, possibly prepare in the best interest of the mediation community. So what I mean by standard operating procedure is how to build a
Thank you, Anurup. I think that the kind of passion with which you spoke resonates with most of us over here. And I'm very thankful to you for highlighting the importance of establishing those necessary SOPs, the processes, so that the institutions continue and notwithstanding what happens to the founders. Because that is something which we really lack here in India, as he rightly pointed out. And in fact, a couple of months back, there was a recent conference in Hyderabad organized by the IMC. Where I summoned up the courage to say, first of all, to express gratitude to the courts, to the judiciary, for bringing mediation to this level. Okay, the kind of traction, the kind of visibility that mediation obtained. It's all thanks to the efforts that have been put in by the Mediation Conciliation Committee of the Supreme Court. Now, it's been 18 years since the court and mediation program has been working in India. And one of the things that I said was, is it time for the judiciary, like a benign parent, to step back and tell the child, the mediation child, look, you have a majority, now you're on your own. So we will just guide you, but you do things on your own. So is that time come now? Is one of the questions that I had posed. And I think Anurup also more or less. I hope I understood you right, Anurup.
Yeah, absolutely, Jawad.
Thank you. And next speaker, because we are running short of time. So our next speaker is Lee J. Berman, who's the mediator. I hope I pronounced the Berman correctly, because we are more acquainted with S.D. Berman and R.D. Berman. So this is L.J. Berman. So thank you so much, Mr. Berman, for joining us. He's a commercial mediator, a trainer, and an author. And he works with people in person and virtually to resolve disputes and settle complex litigation, primarily in business, entertainment, employment, real property, and construction. So he has an office, the mediation offices of D.J. Berman, and he also teaches in the University of California, Los Angeles, UCLA. Thank you so much, Lee, for joining us today. My question to you is, I think the USA can be called as the pioneers in mediation, because way back in the 1970s, you started the multi-door courthouse concept was implemented. And you have been at the forefront. Mediation has grown organically in the US. Without any legislative support. I don't even know whether there was any kind of institutional support. But how did it evolve? I know it's going to take you a very long time to say all that, but
thank you. So thank you for having me. Thank you for the question. And just to be really clear, in my mind, mediation evolved in India as a way of life and as a way that people approached conflict. And I think, as you say, in the 70s, we institutionalized it with the multi-door courthouse concept that came out of the Harvard program on negotiation. Since that time, I think, as you say, in the 70s, we institutionalized it with the multi-door courthouse concept that came out of the Harvard program on negotiation. Since that time, I think Texas was the first of our states to order people into mediation when they had a litigated case before the court. And then California, with all of the litigation that we have here, California was the one that had the most meteoric rise in the number of cases. Just in the county that surrounds Los Angeles, just the small county, we have 40,000 members of our bar association. And that county court system at its peak was referring up to 35,000 general civil mediation cases a year out to civil mediation to resolve them before they would go forward and see a judge. So we've evolved rapidly. But I don't know that we invented anything. I think we adapted it and perhaps institutionalized it. And it was with the support of the legislation in California, where the legislature told the courts, you will start this kind of a program. And fire hose now. Cases were being fed into the mediation process, and we were just trying to keep up. So I see you walking back to the microphone. I'm so sorry for that.
No, I thought, I mean, is there anything more that you would like to say?
Sure. Yes. Once mediation became mainstream and popularized through the legal, pardon me, I'm sorry, through the legal and justice systems, what's evolved here that's been very unique is the business around mediation and the mediation marketplace, and how lawyers and real parties in interest can access mediation. And so what it does is there are these businesses who will lease an entire floor or more of office space in a city and break it up into small conference rooms and have a receptionist out front. And they'll serve, food throughout the day and coffee and tea and everything like that. And they'll do advertising and marketing and promotion for their independent mediators. So if I were with one of those panels, we call them, or a provider organization, they would do all of the scheduling, all of the billing, all of the logistics around the mediation. And then on the day of the mediation, they would provide the real estate, the space, the office to do the mediation, or the several offices, if it's required to do the mediation, as well as all the marketing and promotion of the mediator to get the cases and all of that. So they work very much like our real estate industry does here, in that a real estate agent has to be with a broker who provides all of those similar. So sorry, I just got off of an 11-hour flight, but who provides those similar sorts of services. And then they get paid by taking a percentage from the neutral's rate on that case. But for that, they do all the back end support, the office support, and they help create a marketplace. They go to conferences and put up booths and promote mediation and alternative dispute resolution, and they promote the individual neutrals with their headshots and their biographies and that sort of thing to try and bring them more business. And all that's part of the percentage you pay them. What has happened in our marketplace is, let's say two lawyers come together and either they're ordered to go to mediation or them more business, and all that's part of the percentage you pay them. But what's happened in our marketplace is, let's say two lawyers come together and either they're ordered to go to mediation or they decide voluntarily to go to mediation. Normally, 10, 15 years ago, they would say, who do I want to go to for my mediator? Do we want to pick mediator 1, mediator 2, or mediator 3? But now, because these provider companies have become so popular with the users of mediation, the attorneys who hire the mediators, and in our marketplace, that's how it works, that the parties share the mediator's fee. And so they become so popular that now the conversation isn't, do we go to mediator 1, 2, or 3? Now the conversation is, do we go to company A, company B, or company C? And I've overheard lawyers saying, I like company B because they serve the best lunches. Or I like company C because there's a case manager over there who always gets me a good mediator. So now mediators have become, in that system, have become almost the product that the company is selling or providing. And the company controls the conversation about who the mediator is going to be. So it's a complex system where now these two lawyers might say, okay, let's go to company B. And then once they're there, they may know that they want mediator 1, 2, or 3 at that company, or they may say, here's the kind of dispute we have, here's the kind of case that we have, here are the issues involved, and here are the parties' emotional component and all of that. Who do you think would be the best fit for us? They ask company B, who then says, I think one of these 3 mediators would be the best fit for you, and our choice would be this person. And so they help steer and guide them to who they think would be the most appropriate mediator. But the marketplace is interesting in Los Angeles, especially. Probably 80 to 85% of all of the top successful mediators are with one of these, in our market, 5 or 6 companies now. And I'm independent, and I'm with the American Arbitration Association and their International Center for Dispute Resolution. But that's not an exclusive arrangement. That's the other thing about this. If I, as a mediator, sign on with company B because I want them to help me get business and I want them to do all my billing and scheduling and all of that for me, I have to be, I have to be exclusive with them, and I can't work independently anymore, and I can't work with any other company. I have to do all my mediations through company B, and in exchange for that, they promote me and they invest in me, and they do the work that they do for me. So there are exclusive panels or mediator provider companies, and there are non-exclusive ones who go out and get the cases and then distribute them to the mediators. I'm independent. I'm on one non-exclusive panel, and then I'm on several court panels where they can pick me independently. So we have a very stratified marketplace with lots of choices and lots of options. So I don't know if that leads to any questions that you all might want to know that would help translate this into your system and how it works there. But here it's been a very interesting institutionalization of the offering of mediators into the marketplace.
Oh, thank you so much. I mean, you opened our eyes to so many different possibilities.
Yes.
Yeah. And I mean, there are a whole load of questions that I would like to ask you, but unfortunately, we don't have the time for that right now. Perhaps some of the time that I will request EMW to organize an exclusive webinar where you can come and explain to us how you do it in the US, because this is very enlightening, because this gives us, so many ideas about how to go about doing things in India. And
there's so many options out there. I hope that this encourages people to think creatively about how they go to the marketplace as mediators, and how business people might help be involved to help mediators who may or may not be good at promoting their own business or running their own business.
Absolutely. Thank you so much.
Thank you for having me.
Thank you. Thanks for joining.
Thank you very much.
And may I now request our Honorable Chairman to give his concluding remarks?
So a very interesting session is over. Even though I had made before she is here, we have to conclude this session. As far as the opinion of the speakers are concerned, one thing is final: institutional mediation has to be there. There is no dispute about it. So Jawad, as an opening batsman, has scored the century and is man of the match. Jawad spoke about positive attitude, the 3 skills required of a mediator, and the credibility of the institution which imparts the mediation or undertakes the mediation process. That is the crux of the matter. And when we talk of credibility, as Mr. Chandok said, the various evils of an institution which is paramount and present throughout the country, and what he talked about, bureaucratic interference, is one thing which has to be taken care of. And in my opinion, the best people to take care of is the mediators themselves. You have to stand up against that and ensure that the bureaucracy does not take over the system of mediation. Because our country has had the experience of institution being headed by bureaucrats. An electricity board does not have an electrical engineer, but an IAS officer as its chairman. The port trust does not have an technical person, but a IAS officer. Even now, I am in the Armed Forces Tribunal, and I find in many places, it's not the men in uniform who take the decision, but they have to convince a bureaucrat as to why a decision has to be taken in a particular manner. So those are the things which have to be taken care of, and the best persons who can ensure that it is done are we, the mediators ourselves, and the persons interested in mediation. And I am positive that when we can fight for our independence and see that the Britishers go away, this is a very small thing, and we can all ensure that we have a mediation bill free from all these impurities. One thing I would like to, I noted when Madam Uma spoke about it, the decision or a mediator's profession and his efficiency affecting the society at large. That's a very important point which she put it, because it's also close to my heart. Whenever I go and address judicial officers, I always tell them that what comes before you as a file or as a case is not a bunch of problem. It's a problem at the very first instance concerning a human being, and that problem, if not resolved in the correct way, manifests into a problem for the family and ultimately to the society at large. So therefore I always tell the judicial officers, don't treat the case as a bunch of papers or file, treat it as a problem which would have far-reaching effect ultimately on the society, and to try to resolve it in a manner that this is avoided. And that is precisely what Madam Uma said we should do about it. So one thing about mediation I would like to share with all of you is, in my tenure as chairperson of this Armed Forces Tribunal, I tried to introduce mediation in the army, and I have been successful in it. Initially I had certain problems, but could do it, and the only issue was that the officers should be trained and they will do the mediation for the institution. We did 3 batches of 40 hours mediation training in the Institute of Military Law in New Delhi. 2 of the trainers who participated in that training program, Pushp and Neena Khareji, are here. We trained batch of 3 sets of officers, 40 each, 120 of them, all from the rank of majors to brigadiers. And when I went to take feedback from the officers as to what is their opinion about mediation, what is their experience of being a trained mediators, the answer I got was, sir, it has changed our day-to-day concept of dealing with our Jawans and the soldiers. And the example which struck me one was, a colonel told me that as a corps commander, whenever a Jawan or a soldier comes to me, कि साहब गाँव जाना है, छुट्टी चाहिए, so I just don't even listen to him. कोई छुट्टी नहीं, काम नहीं, जाओ. But now, when he comes to me, I ask him, sit down, क्यों जाना है, क्या कारण है, and in 80% of the time, I give him the holiday. That is what mediation did, and I feel that mediation is not only required for resolving of dispute, it also has an impact on how people administer their day-to-day executive work and how they deal with others. So without wasting much time, thank you Pushp and Manjira for having given me a platform to express a few of my thoughts, and having heard the stalwarts of mediation today in this session. Thank you very much. Jai Hind, Jai Bharat.
Good afternoon, ladies and gentlemen. I stand before you as the clock ticks down on an extremely engaging and illuminating panel discussion on institutional mediation, where we collectively journeyed through various insights by these very nuanced and experienced professionals on this challenging yet vital subject. So I request you to join me in a resounding round of applause for a memorable and successful panel discussion. So firstly, I would like to thank Honorable Mr. Justice Rajendra Menon former Chief Justice, Delhi High Court, Chairperson, Armed Forces Tribunal, New Delhi, whose abundance of experience and knowledge has added an invaluable and distinct layer to the discussion. I kindly request Mrs. Pujari Kavita Bhatia, State Coordinator, EMW Gujarat, to please felicitate him with a token of our appreciation. Secondly, I would like to extend my thanks to Mr. K.S. Sharma for his exemplary work throughout the duration of the panel discussion and for their exceptional observations and examples. I kindly request Mr. Arvind Khurania, State Coordinator, EMW Haryana, to please felicitate him with a token of our appreciation. Moving on to the panelists, I would like to express my gratitude to Ms. Uma Ramanathan, Advocate, Senior Mediator and Master Trainer of Mediation, for her invaluable contributions, which has enabled us to examine the subject with a lens that is both microscopic and shaded with decades of experience. I would kindly request Mr. Rajesh Batra, State Coordinator, EMW, Assam, to kindly present her with a token of our gratitude and appreciation. I would also like to extend a heartfelt thanks to Mr. A.J. Jawad, Senior Mediator, Trainer and Partner, KD Lex Chambers India, whose passion for justice and resolution shines through every insight that they have provided, and whose unwavering dedication to the cause of mediation is not only infectious, but also transformative for the young minds and also the professionals that are present here. I would kindly request Ms. Lata Prasad, State Coordinator, EMW Bangalore, to please present him with a token of our appreciation. Thank you, sir. Lastly, I would also like to thank our online speakers, especially Mr. A.S. Chandyok, Senior Advocate, Senior Mediator, President of Madhyam, and former Solicitor General of India, Mr. Anup Omkar, Advocate, Senior Mediator, and Founding Partner of AK and Partners, and finally Mr. Lee J. Berman, Commercial Mediator, Trainer and Author from the USA, for digitally gracing the occasion and providing their vital contributions to the challenging subject at hand. Thank you.
Excuse me, is it correct? It's working? Hello? Yeah. Yes. Thank you. Hello. Thank you. Excuse me, ladies and gentlemen. Her Excellency is likely to reach the hall in another 2 to 3 minutes' time. So let us all be seated. Her Excellency the Governor of Telangana is reaching the hall in another 2 to 3 minutes' time. So I request everyone to be seated. Push the stickers of who will sit where, the stickers. No sticker. Okay. See, see, there is a.
Relations at Hyderabad. She is a part of my family, which has created in all of us serious interest in mediation and a sense of urgency to promote mediation in Telangana state. I see in it is an opportunity to help both the litigants and the courts of justice, and to bring down the sufferings of the litigants, to thereby impact their lives positively, and to bring down the heavy load of pending cases on court of justice. It was indeed a nice gesture on the part of Her Excellency, Dr. Tamilisai Soundararajan Garu, Governor of Telangana State, having accepted our invitation in the midst of our busy schedule to be with us on this auspicious occasion. I take great pleasure in welcoming her. When we are approaching, especially myself approach Honorable Mr. Justice Ujjwal Bayan to be the part of this program, he readily accepted our invitation. Generally in day-to-day administration, what I observed, always he encouraged us so far as academic programs. So I am very much thankful personally on behalf of myself and the Bar Council, especially on behalf of this platform. And this indeed an August assembly, 3 sittings, judges from the High Courts of Delhi, Kerala, Guwahati, the chairman of Legal Service Authority of Telangana, the chairman of Armed Forces Tribunal, and our own Mr. Justice L. Narasimha Reddy Garu, the former Chief Justice of Patna High Court, are with us, besides so many stalwarts, eminent persons on mediation side. I welcome all of them with folded hands. I welcome all the delegates and mediators parliament who have reached here, traveling long distances from all over 4 corners of India. On behalf of Telangana state, I welcome all of you with love and affection. I wish today's mediators parliament is successful. Thank you one and all.
Mr. Narasimha Reddy, may I now request Justice P. Naveen Rao, Executive Chairman of the Telangana State Legal Services Authority. It's not there. Sorry. The next is addressed by Ms. Push Gupta, who is the Chief of E-Mediation Writings and the woman behind this show. Thank you.
Good morning everyone and namaste from mini India. We have here with us the whole representation from all parts of our country, and we are blessed to have the presence of our esteemed dignitaries and guests. So Honorable Dr. Tamilisai Soundararajan, Honorable Mr. Justice Bhuvan, Honorable Mr. P. Naveen Roy, he is not here joined with us, but we have received his blessings for so. Honorable Mr. Justice L. Narasimha Reddy, Honorable Mr. Justice Rajendran Menon, Honorable Mr. Justice Mohammed, Honorable Mr. Justice Dr. Sudhir Kumar Jain, Honorable Mr. Justice Kalyan Rai Surana, Honorable Mr. Hari Babu, Mr. A. Narasimha Reddy, Dr. L.V. Subba Reddy, and Mr. Shriram Panchu, Mr. Amarjit Sanduk sir, and we have Uma Ramanathan ma'am joining us here live for this session, Mr. A.J. Jawad sir, and our whole team. On behalf of everyone in this room, ma'am, with all our team, whole team of Pan India mediators, ma'am, this is everybody. We have our coordinator here from Haryana, Mr. Arvind Khurania. So he is named EMW as Mini India because we have representations from 32 states and UTs of this country who have joined together for one voice. When we called for this EMW, we believe in a quotation which says, don't be a voice, be a voice, not an echo. So you have to be voice of your own people, which is a mediators community, and we respect our advocates also. But we want to be the voice of millions of people who are here in this country, who are aggrieved and who are there in conflict and they have problems in their life. Our judiciary is already contributing a lot, ma'am, towards the dispensation of justice. But just because there's so much of backlog of cases, we thought this is the right time that E-Mediation writing holds a conclave, because generally Parliament is believed to be an assembly and a conference of people who are like-minded people who want to raise public affairs public issues which can be deliberated and consulted amongst them, and their voice can reach out to the government that this is what we need in our country and this is what a problem is which can be cured. And mediation, we feel, is a process which is a democratic process. And this is how the name of Mediators Parliament came, though right now in our country Parliament is much in talk. So it makes lot of sense to have a deliberation as Mediators Parliament. And E-Mediation writing, the logo of our organization is of the mediators, by the mediators, for the mediators. So ma'am, my request to you, may we have from the state of Telangana and in the presence of our Chief Justice of Telangana High Court, if we can start a project where they have a mediation training in every taluka district for the common man. Ma'am, it is a prevention, it's better. You are a doctor and I must tell you that I too have a black and white coat in my home. So my father is a doctor, my brother is a surgeon, and I have a gynecologist sister-in-law. So we have a same combination at home, that black and white combination, both white and black coats we have, and they are really, everybody is proud of the services which doctor have done, and ma'am, we are aware of your services to the nation in different varieties and categories you have done. So may we request you, because this 40-hour trainings, ma'am, and I would request you be the first person to enroll for this 40-hour mediation training. And ma'am, you will feel the change in your own self. It changes a person. And we say it's a journey of a human being for being human. Because many times the differences, which are inflated with just different of opinions and perceptions can be cured if we reframe our language, we reframe our words. Words have power to heal and hurt. We can convey our same thing, but we can use some positive words to a person with whom we are in difference. So it is not necessarily that you have to have your arms and ammunition to hit a person to resolve a conflict. So mediation is one thing, ma'am, and I promise if you take a lead to be our first trainee for 40 hours mediation training, then Telangana state is going to be the role model for India to have the mediation training where everyone in the home, in the corporate houses, organization should go through this transformative exercise. Just 40 hours of investment, and today with these, we have kept the topics which are so relevant for the mediators community, because that makes sense for us. Deal mediation, which is another very important topic, ma'am. Mediators are generally perceived as if they are required only once the conflict have arisen in society, and they need some third neutral person to help them, facilitate them, they resolve their disputes. But mediators are much more to contribute, ma'am. They can facilitate a dialogue between two people who wants to negotiate for anything. So it's more, mediators are not just, we are not waiting for conflict to happen and then we come in. No, we are quite different from courtrooms. We can be much before that. So in presence of our esteemed dignitaries, Honorable Mr. Chief Justice here, we are making a request, let mediation grow further from a common man to a common man. So courts are already dispensing lot of justice. Government is doing exceptionally well, and we have mediation bill right now, which is most likely to be a statue in coming monsoon session. So with folded hands to our esteemed dignitaries on dais, my request to the organizations, to the government, to the judicial system, let we have the Mediation Act as soon as possible, and mediators' voice is heard. Voice of people who wants to resolve their conflict and differences be heard, and let us all join hands together from all over India and from international arena also, where it is said they have done lot for the mediation. Let mediation in times to come be the only, India be the only country from where we've already involved the foreign lawyers to come and practice in mediation. So we are looking for a day when the mediators from outside India would want to practice mediation in India. That is our vision, and together we all are here to contribute our little bit. So to everyone across who have joined us on YouTube, through Zoom, thank you, heartfelt gratitude to everyone. Thank you so much, ma'am, for pledge. Thank you, sir.
Thank you, Dr. Pushp Gupta. May I now request Honorable Mr. Justice L. Narasimha Reddy, the former Chief Justice of the High Court of Patna, to address us.
Her Excellency, the Governor of State of Telangana, Dr. Tamil Saiji, Honorable Justice Ujjal Bhuyan, the Chief Justice of High Court of State of Telangana, my dear friend and Chairman of Armed Forces Tribunal, Sri Menanji, friend Sri Narasimha Reddy Garu, Manjiraji, Pushp Gupta ji, Subbareddy Garu, and my friend there, honorable judges from different parts of the country, learned advocate friends from across India, my namaskars to all of you. At the outset, I congratulate the EMW on successful completion of 3 years, a great service to the society and a true service to the society they are undertaking. Mediation, according to my understanding of things, I had small experience both as an advocate, as a judge, as an arbitrator, and an ordinary man. But the effective method of resolving this dispute between individuals or agencies only mediation. Because adjudication will leave one of the parties dissatisfied, howsoever effective and legal the adjudication may be. And it doesn't end at one place. It has got a series of remedies. Arbitration, it was conceived to be an easy and effective and cheap remedy, but experience in the recent past shows that it is neither cheap nor fast, because it has got its own trajectory, in the sense after so much of hearing, an award comes, thereafter it will be subjected to litigation at 2-3 tiers. Mediation, on the other hand, will address the core issue and put an end to the misunderstanding of the parties. And once that is done, the individual will be able to concentrate on his other important aspects. Otherwise, for some people, the pursuing of litigation happens to be the life mission. And we have seen several families and persons just involved only in that. Now, the mediation, I have got an experience in this behalf also. In the Visakhapatnam Port Trust, there is a practice of incorporating a clause in the agreements to the effect that before arbitration is taken up, there shall be an attempt to get it resolved through expert opinion. So 2 or 3 times they came to me, and incidentally, both the parties will choose an individual, and when that is addressed, both of them will be informed where they stand in terms of the conflict. And once they understand, and once the suggestion is given that this will be in the interest of both, and both they can agree, and the dispute or the future dispute will come to an end. I can proudly say that thrice I made an attempt, and a dispute which was to result in huge expenditure and time for the parties has ended in a very amicable manner. And it was, the mediation used to be part of our society, within the village, within the family, within the community. Unfortunately, we have neglected it. But in a lighter vein, I can say, the attempt is only at cross purposes with the legal profession. If you put an end to the litigation, what for you are there and what for courts are there. It is said that one senior advocate was there. He was handling several partition suits and so many others. His son became advocate. Then once he was in, went to attend that case. He was also a bit having the same idea as all of that let us bring about solution. Then there was a proposal in the court for some mediation, and he accepted for that decree in terms of those agreed terms. Happily came and reported to his father, saying that, sir, father, I have brought an end to the suit and we got this. The father was angry. Useless fellow, what you have done? It is about that suit. I have constructed this house. I performed marriage of your sister, and I got educated. And what you have brought an end to that? What a foolish thing it is. In a lighter way. But I still remember a suggestion given by Justice Majmudar. He was invited to bar after he became Chief Justice of API Court. He said that what should be the spirit of an advocate? Then in one case, he said, with his own experience in Gujarat High Court, he said, one litigation was there and one advocate was handling the case. A suggestion in terms of, with regard to some right of passage, then the settlement suggested by the court was to result in some inconvenience to the advocate, who was the immediate neighbor of the client. But the advocate underwent that the inconvenience on account of the easement and accepted for that. And that should be the spirit of an advocate. Even at the cost of undergoing some hardship, we should ensure that an issue is resolved amicably and properly. Even now, we can, nowadays, when persons are hell-bent upon sticking to their own stands and powered with their own finance and all that, they should be impressed upon saying that there is no point in continuing the litigation endlessly, and it is in the interest of everyone. Because one litigant, the litigation is not confined to a person alone. His family is involved, his establishment is involved, and so many other things come into play. And wherever it is possible, best thing is to resolve it through mediation. If you are able to impress the society and the stakeholders, we will be going a very long way in bringing about peace and tranquility in the society. And I thank the organizers for providing me this opportunity to speak in the august presence of all experts and great personalities. Thank you all. Namaste.
Thank you, Honorable Mr. Justice Narasimha Reddy, for your kind words. May I now request Honorable Justice Ujjal Bhuyan, the Chief Justice of the High Court of Telangana, to address us.
Her Excellency, Dr. Tamilsai Sundararajan, Governor of the State of Telangana, Mr. Menon, former Chief Justice of the Delhi High Court and presently President of the Armed Forces Tribunal, Mr. Justice L. Narasimha Reddy, former Chief Justice of the Patna High Court, Mr. A. Narasimha Reddy, Chairman of the Bar Council of the State of Telangana, distinguished dignitaries on the dais, honorable judges from different high courts of the country, senior advocates, and members of the mediation family. A very good afternoon to all of you. I have checked my watch. It always invariably happens with me. I come prepared to say good morning, but as and when my turn comes, it becomes, I have to say good afternoon. But doesn't matter. A very good afternoon to all of you. I am very happy to be present here today in this mediation conference. I congratulate E-Mediation Writings for successful completion of 3 years, and I wish the organization the very best for the future. As my previous speakers have said, mediation, as we all know, a method of the alternative dispute resolution process, is not new to our country. Since time immemorial, we have followed mediation for settlement of disputes within the family, within the community, within the trade, so on and so forth. Section 89 of the Civil Procedure Code has only given statutory recognition to the time-tested and the traditional method of dispute resolution. Well, in the 70s, there used to be a magazine called Illustrated Weekly of India, and we used to follow that, and a lot of pictures used to be published in that magazine. It was edited by Khushwant Singh. So one of the pictures published there in that magazine, somehow it got stuck with me. And the picture was of a village girl in the Punjab carrying 17 bricks on her head, and still she could manage a smile. And the caption was that 17 bricks and still she could smile. So, interpoling that image, today's context, I was wondering whether if we put one more brick on her head, whether she will be able to walk or whether she will be able to smile. But perhaps she may still be able to walk, she may still be able to have a faint smile. You add one more brick, I'm sure she will wobble, and I'm sure she won't be able to smile. You add one more brick to it, I think everything will collapse. So, every system has got a maximum level, utility level. Maximum, it can operate up to a maximum. Beyond that, it cannot. Our judicial system is bursting at the seams. We can't stop people from coming to the courts. Approaching the court is a fundamental right. We can't deny them. So therefore, this burgeoning, this backlog, this arrears, court pendency is an issue. So therefore, we are bound to look at alternative methods of dispute resolution. Arbitration is certainly an alternative method of dispute resolution, but as our experiences have shown, it has become very, very expensive, and ultimately it comes back to the court system once again. After the award is passed, and then litigation starts. So we are actually postponing the litigation. So therefore, of course, Lok Adalats under the Legal Services Authorities Act have achieved a modicum of success, but all matters cannot be decided through the Lok Adalats. This is where mediation comes in. But it will be wrong only to look at mediation from the prism of disposal of cases as an alternative method of reducing the court pendency. Certainly, this is one of the prime objective of reducing court pendency, but mediation, as we know, is not right-based. It is interest-based. So therefore, when there is a resolution of a dispute through mediation, it helps in not only restoring relationship, be it relationship within the family or commercial relationship, but it strengthens, it cements such relationship. So therefore we say it's a win-win situation. So, I can share with Ms. Gupta that we in the Telangana High Court, on the starting of our holidays, summer holidays, today is the last day, from tomorrow we are again going back to the courts. All the judges and the family members, we had gone to a retreat. We stayed there. We invited experts from the Samadhan Center, Delhi Court and Expedition Center. And all of us, we underwent some kind of a mediation training. All the judges and some family members also joined us there. And in the evening, we had, of course, meditation programs. So mediation and meditation going hand in hand. And I'm sure from the feedback that I have got from my brother and sister judges, they say it has opened our doors and our eyes and ears to a new world altogether. This is how we can look at our dispute. The problem is that it's infrastructure related issues. We have lack of mediators, lack of number of mediators, the facility, the infrastructure is not there. Many mediation take place in the court corridors itself. Mediation can't be one-off sitting, can't be one-off, it needs patience, perseverance, and several rounds of discussion to achieve some kind of success. I'm sure with the lot of trust that is being given to mediation and alternative dispute resolution, I'm sure things will brighten up with the presence of Her Excellency, the Governor of Telangana in our midst. I'm sure the mediation movement in the state of Telangana will receive the much needed boost. I thank the organizers for inviting me to be part of this conference. I wish the conference all success. Thank you very much.
Thank you, Honorable Justice Mr. Ujjal Bhuyan. Now the moment comes that we have been waiting for, the inaugural address by the chief guest. Her Excellency Dr. Tamilisai Soundararajan needs no introduction. However, I will present a few facts about her illustrious career which many present in this august audience may not know. Her Excellency, who hails from Kanyakumari district of Tamil Nadu, took charge as the Governor of Telangana in 2019. She is the first woman to hold this position. Her Excellency has a remarkable public and social service background spanning over 20 years. She started her career as a medical practitioner after completing her MBBS and post-graduation in gynecology DGO. She underwent special training in ultrasound and fetal therapy at Toronto, Canada. She later became assistant professor at Sri Ramachandra Medical College and Research Center, a prestigious medical institution at Chennai. She was a student leader at the Madras Medical College during her MBBS days and rose in her political career steadily, ultimately becoming the president of the Tamil Nadu State BJP, which position she held from 2014 to 2019. May I now request Her Excellency to address us.
A special, as it is said, good afternoon to each and everyone here. Honorable Chief Justice of High Court of Telangana, Shri Justice Ujjal Bhuyanji, Shri Narasimha Reddy Garu, Chairman Bar Council of, he has come? Okay. Yeah, Telangana, Shri Justice L. Narasimha Reddy Garu, former Chief Justice of High Court of Patna, Dr. L.V. Subba Reddy Garu, Director Litigants Prime, Ms. Pushpa Gupta, Advocate, Mediator, Coordinator, Chief E-Mediation Writings, Ms. Manjira Venkatesh, Advocate, Coordinator, E-Mediation Writings, Telangana, Mr. Tankachan, BP, Advocate, Mediator, Senior Member, E-Mediation Writings, Honorable Judges, other dignitaries seated on and off the dais, and esteemed media friends and all the other participants. You all a very, very special occasion. And whenever Chief Justice Sri Ujjal Bhuyan, when he told, I start telling good morning, and always I am saying good afternoon, but it is better than good tomorrow or good day after tomorrow, because we have to quicken everything, because we know when we plan, sometimes nothing goes to the online. So sometimes we be able to push to be delayed, and that is why more mediators are in the action. And it is really very fortunate to be in this dais. But the mediation, it's a different subject, and I have to say, when I told my office, they thought it is meditation or same, except some spellings, because we can say that it also needs meditation. It needs peace of mind and this mediation, as it is said that the passage of bill and the piling of cases. And as our Chief Justice told, if you put one brick, okay, two bricks, okay, but three big bricks, okay, but the same person will pray God, God, I am not bothered about the bricks on my head. Please give strength to bear all the bricks. That is the mediation work. So that is very much needed. And as I said, some peace of mind is needed. And I was reading because the subject is also very new to me. And when I was reading about that, one person was asking, all these mediators not very successful in their marriage life, why? So they were telling the husband always asks the wife, why? So when he always asks why, so this is the problem, because he asks his clients why. So he gets a solution. But when he asks the same thing in the practice of approaching a client, then definitely his wife will get angry. So it's a need of the hour. And mediation, as it is said, E-Mediation, and I'm really appreciate the organizers, the E-Mediation writings and mediators, the Parliament 2023, 3 years anniversary celebration, and 2 years gone because of pandemic. And in spite of pandemic, as it is said, it is Little India. And Little India, the organizers and the members are from all over the country. So the legal system, for everything they go to the court. For example, I was reading a magazine, then one mother-in-law and daughter-in-law, always disputes will be more with them, no. So before and all, families were able to solve the problem, now they go to the court. The problem was the daughter-in-law hit the mother-in-law during her ride in a bike. So the judge asked her, why you hit your mother-in-law? Are you not able to control your bike? She told, I am unable to control my mother-in-law. So these are nowadays, public, interest litigation has become public nuisance litigation, you know, all this, because so many cases. We all know, as doctors, when really patients who need are attending the OP, it's all right. In the casualty in the ICU, if you see a patient of heart attack, it is okay. But to the ICU, if a patient with only my thumb is paining, my leg is paining, so if the case is piled up, so how can I attend the myocardial infarction patient? In a lighter sense, when we were medical students, when we attended, my cardiologist was narrating one experience of him. One day a patient landed with cardiac pain, and he had typical myocardial infarction. So they tried immediately, emergency bypass was done. Then he was admitted in the ICU. The next day when he was going rounds, he was asking the patient, because I am a doctor, I can narrate only that exam. They told white coat and black coat, because in my house all are white coats only. So he was asking, how are you? What, sir, what type of treatment? I am totally dissatisfied. I am totally disappointed. What happened? So from morning I did not pass motion. So my sir was telling, we have saved him from cardiac arrest. but he is only worried about his passing motion in the morning. So what is irony this? So this is that. In all the professions we face, we will be dealing with greater things. But at the same time, we have to face certain small things. So mediation is very much needed in that occasions. And as it is the E-Mediation, and you are all the experts, and I am a person, a different person, because I am the white coat among the black coats. But I am really very happy, as your organizer said, the governor may be the first person to take it. I am ready to take, because I am good in taking challenges, and I am good in take mediation also. Because most of the thing I am doing that only in Telangana, no? So I am very much experienced in that. So I am ready to, whatever the challenge you give it to me, I am ready to take. But I am really very happy to attend this program. And my request is, whatever may be the courts, as I said, as I always say, the government hospitals are the last hope of the poor patients. Like some of the disputes, even though they don't have any political background, or if they don't have any financial background, but that courts should be the last hope for the most marginalized people. So that is my, because you all know, as legal professionals, you know that you help the marginalized people, poorest of the poor, but sometimes getting the solution for them, it is the most important thing. So these type of organizations and mediation definitely help them and to release the burden. And strong mindset should be there. I always narrate one story. One king wanted to practice his cock for fighting. So he gave that cock to a practitioner who practiced the cocks for fighting. So he went to the teacher and he gave the cock. And after 1 month he came and he told, when he saw the cock, some cocks were shouting at distance. Hearing that, this cock spread its wings and was about to fight. Then the king was very happy. Oh, my cock is ready for fighting. So I will take my cock. Then the trainer told, no, your cock is not ready. Then after 1 month he came. At that time in front of the cock, some of the cocks were fighting. At that time also it spread its wings and was about to fight. At that time then he was very happy. So hearing the cocks fight and visualizing the cocks fight, my cock is ready. So now I will take my cock. Then trainer told, no, your cock is not ready. Then third time when he came, some cocks were fighting and some cocks were fighting in front. This cock was freely moving without any disturbance. Then the king got very much worried. See what is happening now. Before hearing the voice itself, my cock was ready. He told my cock was not ready for fighting. And after that when I came, seeing the fighting cocks, my cock was ready. Then also you told the cock was not ready for fighting. Now see, there is fighting and there some cocks are fighting. All sounds are here. But this is very calmly going here and there. What happened to my cock? No, your cock is well trained, you take away the cock. Then he was telling, what is this? Then he told, now your cock is confident that when the fight comes, we can deal. So, no need to go for fighting. Let them fight. Let them fight in front, let them fight at far. But when it comes me, I will manage it. That is mediation. So that confidence is there for the mediators, and I'm really very happy to attend this program, and I wish you all the success, and this little India will be a successful India. Thank you so much.
Thank you, Your Excellency, for the interesting and the humorous speech. Now is the time to felicitate Her Excellency. I request Tharunam Siddhantam to coordinate the felicitation.
Good afternoon, everyone. Esteemed Chief Guest, Her Excellency Dr. Tamilisai Sundararajan, the Guest of Honor, Honorable Mr. Justice Ujjwal Bhuyan, Honorable Mr. Justice L. Narasimha Reddy Garu, the Chairman of the Bar Council of Telangana, Mr. A. Narasimha Reddy, the Chairman of Litigators Prime, Dr. L.V. Subba Reddy, the Office Bearers of E-Mediation Writings, Pushpa Gupta Ma'am, Mr. V.P. Tankanchan and Ms. Manjira Venkatesh, the dignitaries of the dais, Honorable Mr. Justice Sudhir Kumar Jain, Honorable Mr. Justice Mohammad Mushtaq, Honorable Mr. Justice Rajendra Menon, learned advocates and mediators, ladies and gentlemen. Now I humbly request Her Excellency to accept a memento as a token of our gratitude to her. I request the Chairman of Litigators Prime, Dr. L.V. Subba Reddy Garu and Pushpa Gupta Ma'am from Delhi to do the honors.
Thank you, Tharunam. The next is keynote address by Mr. Sriram Panchu, who is the doyen of mediation in India, the pioneer of mediation in India. He'll be addressing us online.
Excellency, the Governor of Telangana, Honorable Chief Justice, Honorable Chairman of the Bar Council, Justice Narasimha Reddy, Justice Rajendra Menon, Justice Mushtaq, Justice Jain, fellow mediators, ladies and gentlemen. use the word parliament for today's assembly, in any parliament, in India. And you have members. But have you thought about constituencies? Parliament is essentially a congregation of representatives of constituencies. Have we mediators thought about our constituencies? Who do we represent? And more important, who do we cover? To whom do we outreach? Who do we empower? And I think we need to pay attention to that, because I think there lies a significant part of our growth for the future. You have wonderful examples in Telangana. You have worked with police to create mediation capacity for those coming with their problems to police stations. But let's think beyond that. An example so simple is something like the Rotary and Lions Club. We have them all over the place. And leading citizens, good people, are part of these clubs, and they meet very often. And they need to hear good speakers about what's happening in important areas. That is a constituency which we can cover. Social clubs, Rotary clubs, Lions clubs. Look at the number of education institutions over there. I think every education institution would like to know about mediation. Not just a commercial or business education. Every institution, whatever it's dealing with, whether it's psychology or any other field, they would like to know how can we resolve problems better. And who better than a good mediator to talk to them? Community welfare organizations, again so many of them, industry associations, national bodies. There is a whole world out there which is waiting to be educated into mediation. And I think that is our constituency. We need to target them. We need to approach them. We need to speak to them. And I think it is our common experience that every time we speak about mediation, you receive a warm welcome. People's lives light up. When we get to know that there is some method like this which can tackle their disputes expeditiously and well and restore relationship. The other thing I would urge my colleagues is to communicate. To write. Even a small piece of writing can make an impact. One paragraph can change a life. One sentence can cover the power of an idea. And it is a tremendous medium to spread the word, the power of writing. Similarly, the power of speaking. And I'm not saying speak to at formal meetings, a drawing room conversation, talking to your co-passenger in an aircraft. Those are again powerful methods of communication. So I think it is the spread, the outreach, and the communication that is going to make a huge difference. And I think we should document our success stories. There are so many success stories about mediation. We should, of course, hide names, preserve confidentiality. But it is from actually knowing about success stories in the small and big cases, across the range of personal and commercial conflict, that people actually get enthused and they say, well, maybe I will try it in the case I have. So there is lots to be done. And it's wonderful to think that we are representatives of mediation. Indeed we are. And we are the forerunners, we are the representatives of the movement. So it's time now to move outside our own little gardens and to embrace larger gardens and larger populaces and cultivate the soil, and the fruits will come. Thank you very much.
Thank you, sir, for your valuable address. If you have reached where we are today in mediation, it was mainly because of you, because of your leadership. And because of that, we, the mediators, owe you a great debt of gratitude. You beautifully drove home the point that mediation is required everywhere. Thank you. May I now request Mr. V.P. Thangachan, the Coordinator-in-Chief of E-Mediation Writings, to address us.
Her Excellency Tamilisai Soundararajan, Governor of Telangana State, Honorable Justice Pujal Buyan, Chief Justice of Telangana, Honorable Justice Justice Narasimha Reddy, Chairman of Narasimha Reddy, and Narasimha Reddy, Chairman of Bar Council of Telangana, and Mr. Justice Rajendra Menon, sir, Mr. Justice Mohammad Mursa, sir, Mr. Justice Sudhir Kumar Jain, sir, all the dignitaries on and off the dais. After the beautiful and interesting presentation from the side of our Her Excellency, I do not want to say anything more. But I would like to say one thing. Our judiciary is facing a very crisis. Around 5 crore cases are pending in our courts. And we have only nearly 20,000 judicial officers and only 12,000 mediators. We cannot address this situation with this short number of judicial officers and mediators. So we need more judicial officers and we need more mediators. So that we should train more mediators. And also the system, our mediation should come out of the 4 boundaries of the courts. That also we should do. So that I hope that our statute will come out very soon, so that everything will change. And I hope that the system will improve within a short period. Thank you all.
Thank you, Mr. Thangachan. May I now request Ms. Tarunam Siddhantam to propose the vote of thanks.
I thank Manjuna Madam for entrusting with me the pleasant task of proposing the vote of thanks. It is easy to say the 2 words thank you to Her Excellency for taking her time for us in the midst of her hectic schedule to be with us and bless us, but it is difficult to do that which she did for us. I thank our guest of honor, Honorable Mr. Justice Bhuyan, who honored us by being present on this occasion and by addressing us. I request Mr. E. Haribabu and Tankanchan VP from Kerala to present him a memento as a token of our gratitude. I thank Honorable Justice L. Narasimha Reddy Garu for being with us today and for addressing us. I request you, sir, to accept our token of gratitude. May I request Ms. Neena Khare to do the honors. We ventured into holding this event in Hyderabad only because of our Bar Council Chairman, Sir Mr. A. Narasimha Reddy Garu, who assured us his support. It is again easy to say thank you to him, but what he has done is something very difficult to do. I request Mr. P.G. Suresh to present Sir a memento. It's already done, sir. This program is organized and executed by Litigators Prime, which functions under the chairmanship of Dr. L.V. Subbareddy Garu, an ever-smiling, humorous and relaxed-looking business leader. Please, sir, accept our token of gratitude. May I request Ms. V. Usha to do the honors. We are very grateful to Advocate E. Haribabu Garu of Litigators Prime, who played a very important role in organizing this event in a grand manner. I thank the leaders of E-Mediation Writings, Ms. Pushpa Gupta from Delhi, Mr. V.P. Tankanchan from Kerala, and Manjira Madam, the coordinator for Telangana, all the state coordinators from all over the country, the members of EMW and delegates, and all of you who made this inaugural ceremony a memorable one. Thank you.
Yeah, humble request to you, Your Excellency. Yeah, humble request to you, Your Excellency. The delegates who are here have come from different parts of the country. And particularly the ladies present here want to have a group photograph with you. And after that, the students of the Andhra Mahila Sabha Law College are here and they also want to have a group photograph with you.
Sir, can we have Honorable Mr. Justice Muhammad Mushtaq, sir, Honorable Mr. Justice Dr. Sudhir Kumar Jain, Honorable Mr. Justice Kanrayan Rai Surana also to join us for this group photo, sir. May we please request you. Please. Along with our learned speakers, and please whosoever come, our learned speaker Jawad sir, Uma ma'am, Chitra, we have Ekta, Romit. Please come, please. Nomita Shah, please come. Please come.
Request everyone to stay back after the group photograph for the national anthem. There is a complaint why only ladies can't, gents joined. Gents also are most welcome to join, please. I said that ladies were particularly interested. All the gents also may join. And after the group photo with the delegates, it will be the turn of the students of the Law College of Andhra Mahila Sabha. The students and teachers, of course. So after the delegates, the students, teachers and the principal of Andhra Mahila Sabha Law College will have a group photo with the Excellency. I think now Manjana is there. You can join there. You can join there. You join. The members of Litigators Prime, which had played an important role in organizing this event, want to have a group photograph. Yeah. So after the photograph with the members of Litigators Prime, please stay back for the national anthem. After, yes. Yeah. So the next may be photograph with the members of the Litigators Prime. Yeah. Yeah. You are also. Okay.
I request this.
Tava
photographers. love to hear your experiences.
Me in a much wider manner regarding my experience as a mediator. And no doubt I have been attached with the mediation since 2003, and it's almost journey of 20 years in my capacity as mediator, trainer, referral judge, administrator of the mediator. You know, I was considered to be a very hardcore judge when I joined the judiciary. Relevant case law, documents of the parties. But gradually, while dispensing my judicial work, I realized that many cases, rather large number of cases can be disposed of, can be addressed without asking the parties to undergo further trial, advance lengthy argument, lead detailed evidence. Those can be. And then gradually my name, which was given by the bar, is the settlement judge. I used to have proceedings. I was just joking before the start of this session, if we talk about the deal mediation, if we address all the issues which a mediator is supposed to deal during the course of mediation, then all the mediators, those who are sitting over here, what they will do in the future. So there will be, big loss to us, but we need to refine the system, include many new things, our system. We are the part of the society. Every society, the conflicts are inevitable. No conflicts can be taken as good or bad. What we need to address the conflict in the right perspective so that a good, creative, innovative solution can be found out. Earlier, the traditional litigative system, that is the court system, with the incorporation of Section 89, we have also started to talk about the resolution mechanism to dispute, to address the dispute. Whatever may be the system, formal or informal, to address the dispute or conflict, the existence of conflict or dispute is the precondition. It is the condition precedent. What I have noticed, I will share one example. When I was functioning as a mediator in T. Cesari Court, there was a dispute between the National Judicial Academy, you must have heard, at Bhopal, with its interior decorator. They were having the arbitration clause, but the governing council, headed by the Honorable Chief Justice of India, they preferred to send the case for mediation, and ultimately the case was assigned to me. What I have noticed is that in the litigation we talk about the position of the parties, but mediation is a journey from confrontation to collaboration, from position to interest. In the mediation we took care of the underlying interest of the parties. In that case I have noticed if many aspects to be considered between the parties, to be entered between the parties, if they have been addressed in the right and proper perspective, the future dispute could have been avoided. There should not be any future dispute, even despite having the arbitration clause. Then gradually I came to know from my experience, although before this program, before talking to audience on this topic today, I never thought much deeper about the deal mediation. But many disputes, they can be at the time of drafting the agreement, at the time of contract, entering into the contract. If the many issues with the help of a neutral third person can be addressed in the right perspective, they can be in a different way, or they can be incorporated in the agreement or future contract, I think we can avoid future litigation or even the mediation also. I have noticed in many cases like that flat buyer's agreement, building buyer's agreement. Recently I was sharing during my lunch also, about a month back I attended one program the role of mediation in construction-related dispute. How, if this type of agreement, if they are properly worded with the help of a neutral person mediator by taking advantage of deal mediation, those disputes could have been avoided in the future. Even I have found labor management dispute, service contract between the employer-employee, even the agreement between the two corporate bodies. Now I am the part of a division bench, the appellate bench, hearing the appeals under section 37 of the Arbitration and Conciliation Act against the objection under section 34 decided by the single bench. I have noticed many times that most of the dispute, they are based on the agreement or contract between the parties. But they are so poorly worded. They are in the most of time, they are in the performa without looking into the underlying interest, the future underlying interest of the parties they have been entered into, if they have been addressed in the right perspective, in the right manner at the appropriate time. Many agreement, many negotiation on the possible outcome, they prove to be futile without any much result because of the absence of a mediator who is expert in the deal mediation, who at that time, because when the section 89 was introduced, it related to the post-mediation. There gradually we also, post-litigation mediation, we have also started to address pre-litigation mediation. But when the section 89 was introduced, we never thought that the mediator can play an active role even before a dispute can arise, a contract or agreement can be matured into the legal dispute or legal conflict. So here lies the importance of our deal mediation. We need to understand, all of you are seasoned mediator, experienced mediator, you have conducted mediation in vast number of cases and variety of cases. And what I see, for many reasons why deal mediation is required. First, if we address contractual obligation at its threshold, before finalizing the contract or agreement, the underlying interest, the concern of the parties they are addressed, it may reduce into the pendency before the court. The dispute will not, conflict will not mature into a dispute, a legal dispute. And today morning also, we have talked about the mediation bill also. Mediation bill is also having many provisions relating to the international commercial mediation and the local commercial mediation also. If we want to advance the cause of India in international mediation, international commitments for international or bilateral or multilateral agreements, we need to have the battery of the mediators who can help, who can facilitate, that is facilitative negotiation before the contract also. Another factor which came in my mind is now India is a growing world power. We are claimed to be the 5th world power in the economy. A lot of foreign direct investment is coming to this country. We have also started to talk in terms of globalization. So if we want to fulfill our international commitment, international contracts or agreement, then we need to have very expert and qualified deal mediators, facilitators, and those who can handle this issue also. Now another issue which also referred in the morning session by one of the honorable speaker, that India is also one of the signatory of the Singapore Convention. Let's talk about the enforcement of international mediation, international agreement. How, before entering into the mediation on the basis of international agreement, commitment, we need to have a glance over the international, our agreements, contract, so that there should not be any scope for future dispute or future disagreement or incompatibility between the concerned party. I I have every reason to believe, even as a mediator with my past experience, many issues, even the family issues, commercial issues, contractual issues, even the IPR issues, they could have been very well avoided. They need not to see the light of the courtroom or mediation room if their agreement, they were addressed in the right and proper perspective. Today, we are having a panel of experts on deal mediation. Madam Chitra is sitting at the right side of me, and three good panelists, they are on screen, Mr. Rahimji, Mr. Claude, and my dear friend Aman Hingorani, with whom I have shared the dais many times also. They would be guiding all of us how to go about with deal mediation, what are the benefits of deal mediation, and why we need to have a class of mediators which can handle this type of new mediation also. I think before 3-4 years, none has heard about the deal mediation in this country. Recently, we have started to talk about deal mediation. When this topic was assigned to me, immediately I called Ekta, Madam, what is this deal mediation? She said it is something related to the bargaining and negotiation. I said, what kind of negotiation? Then I came to know the negotiation, the proper negotiation at the time of when the parties, they sit together, they talk about their future contractual relationship. So what kind of the corrective measures can be taken at this stage so that a mediator with his facilitative negotiation and bargaining qualities and attributes can assist and help the parties to have a meaningful contract and agreement. So now we would like to hear the panelists at the end. If there is something, then I will take opportunity to address my concern also. Thank you, Ekta. Thank you.
Thank you so much, sir. And it's very interesting because when we look at conflicts, we look at issues and underlying concerns that come in later. But even at the time of a transaction, whether it's a general contract or you're looking at a joint venture, or even, where we're talking about the next unicorns of the country, which Anurup was talking about, all of us have interests when we sign the contract. And they're seldom spoken about when the deal is going on. So I remember, when I sit at a table and I'll ask, parties in, say, a joint venture that, how are you looking at integration of employees? How do you look at this going further? My answers are always met with, we'll discuss and deal with it later. Now the thing is, the later usually never comes. And those conversations never really happen unless there's a conflict that happens and then everybody's either in arbitration or going to court, or they're trying to sort of then make up for things. And in the process, what happens to the contract? What happens to the relationship? And so thank you so much for highlighting the fact that, when we're looking at deal mediation, we're looking at perspectives, we're looking at issues, and we're also looking at the language of the contract itself. And that brings me to Claude. Claude, you've done so much work in the field of deal mediation, and there's so much literature also that you've written on it. So if you could share your thoughts with us on deal mediation. Over to you, Claude.
Certainly. Thank you, Honorable Justice. I could not agree more with your words. Good afternoon to all of you. It's a great privilege for me to be with you. Happy 3rd anniversary to E-Mediation. Thank you very much for inviting me. Will you agree with me that mediation is the best dispute resolution technique? Yes, great. Then let me tell you a few words about mediation. Unfortunately, many persons familiar with the practice of mediation today believe that its usefulness lies exclusively in dispute resolution. While mediation is indeed an excellent method for resolving ongoing disputes, I believe mediation may prove just as useful, if not more so, in preventing conflicts before they arise. Parties often come into the negotiation with their own perceptions of the facts, and each side automatically assumes that their view of the situation is fact, and this is the only truth. Therefore, the other side is undoubtedly wrong. Additionally, as each side wishes to maintain the upper hand, they're often reluctant to share information, either about their true interests or about the true alternative options available to them for fear of giving up their hand. offers and counter offers from several parties without giving away any secret information to either side. In this way, the mediator can make a well-informed analysis using all the collected facts which the parties themselves may not have access to. This allows the mediator to have a bigger picture of the issues at stake, which he can then use to guide the process accordingly and to assist the parties to create value-added solutions to their potential agreement. Many of the problems encountered in settlement negotiations are equally present in deal-making. It's also a type of negotiation involving several parties and often differing interests. Why is mediation not frequently employed in the process of deal-making? We all know we should eat healthier, exercise more, take a vacation, etc., but we don't do it. There is something in human nature that does not value preventative care and is more comfortable with crisis management. Why? After many years of deal-making and lots of negotiations, I suggest that human beings respond from their limbic system reptilian brain, which makes us hardwired to be short-term gratification oriented. For example, the stock market rewards quarterly increases, not long-term planning. In our social and business settings, risk takers are penalized and conformity is rewarded. The same philosophy applies to deal-making negotiations. Often the participants and/or their counsels in a deal think, I can do this myself. I don't need any outside help. I don't want any outside influence. I want to retain control. I have negotiated many deals and I don't need a mediator or settlement counsel. In many such instances, these statements and beliefs are accurate. If your opposing party in the deal negotiation has an alignment of interest with yours, if he has either compatible or not incompatible negotiating styles, if they have an equal self-interest in closing the deal, if you have the correct advanced intel to know what's going on in the other camp, if you have the correct pressure point in the other's harbor. I believe one thing emphatically. There is never only one right and never only one wrong. There are only perspectives, personalities, and positions. The trick is in hiring the right person. It cannot just be any old mediator. It must be somebody with sophisticated people skills, well-developed mediation and negotiation skills, sharp business acumen, and a persistent personality. Bringing all the resources to reinforce your negotiating position should be a priority. If you can gain agreement from the other party to hire a deal mediator, the chances for success are improved. If the other party will not agree, still hire a deal mediator to work with your team as settlement counsel. His skills will be invaluable. There have been times where I've been hired by one party as settlement advisor, but I still speak and act like a mediator, i.e., my tone, my approach remain the same. Opposing parties divulge more than they otherwise would, and they want to treat me as a confidant simply because I speak like a mediator. This has been an asset to the team working toward a successful combination. Perhaps now it is time for us to realize that the best conflict management technique is conflict prevention, which essentially embodies the aim of deal mediation. As a matter of example, in the construction industry, approximately 50% of all legal costs are somehow linked with disputes. This statistic alone demonstrates the importance of preventing a conflict before it even arises. Unfortunately, many people fail to realize that future problems could be avoided if a mediator were present during the drafting of a deal from the very beginning stages. Usually, the currently existing process of closing a business deal is more akin to a negotiation involving positional bargaining than it is a win-win optimal deal which benefits all involved parties in the best possible way. This is where a deal mediator or a deal facilitator can prove useful. Parties directly involved in the commercial negotiation can easily fall into many traps and pitfalls which could lead to a suboptimal deal. These pitfalls include dividing value rather than creating value, and parties sticking to their own bargaining positions rather than exploring options for mutual gain. As parties involved in such negotiations are often very inexperienced in proper negotiation techniques, they often end at an impasse, or in cases where a deal is reached, opportunities for greater value creation are missed. The job of the deal mediator in such cases is twofold. The first aim is to ensure that the deal is reached, although this is not a guarantee. And the second aim is to ensure that whatever deal is reached carries the highest possible value for each party. The key takeaway of these aims is the idea of the maximum possible benefit for each side. The advantage lies in the mediator's ability to identify each party's interests and to assist each party in devising solutions to fulfill those interests. Too often, parties enter a negotiation situation such as deal-making with very strong positions. These positions are stated in such a way that there is little room for maneuvering, and parties tend to hold tightly to these positions. The mediator's job is to avoid positional bargaining by focusing on the interests of the underlying needs associated with the positional stance. The mediator can think beyond the positions laid out by each party, and in doing so opens up the zone of possible agreement, and get the parties thinking about collaborative and creative solutions. Another advantage is the ability of the deal mediator to help the parties make a realistic allocation of risks. Although this is one of the most critical steps in preventing future disputes and avoiding unnecessary costs, many parties and their counsels prefer focusing on winning the bargaining game while shifting as much risk to the other side as possible. Let me say a few words about the quality of the deal mediator. He is impartial. He will not demonstrate favoritism for one side over the other. He is independent. His personal interests are in no way tied to the outcome of the deal mediation process. He is able to uncover the interests of all involved parties. The mediator can go beyond asking the what question to asking the why and the how questions. The mediator is able, in asking these questions, to uncover the true necessities facing each party, thus allowing for more creative solutions. The deal mediator has no opinion. The deal mediator's primary task is to facilitate the closing of the deal, but he is not there to offer his opinions. The deal mediator defers the decision-making to the mediating parties. What the mediator will do is to directly address questions and concerns to all parties that they themselves will either fail or not dare to ask each other. Some of the tasks of the deal mediator include managing the negotiation process, ensuring that the deal is realized and on terms to which all parties involved can agree, preventing and if necessary, resolving disputes during the negotiation process and at a later stage during the implementation of the negotiated outcome. By helping the parties to identify their needs and interests rather than stall their positions, the parties will be able to leave the room with a more beneficial, a more balanced and sustainable transaction. Nevertheless, in conclusion, the question remains, why do we need this person? Why should we pay this third-party neutral for a dispute that does not even exist? To this question, I suggest a very simple answer. Think of this person as your insurance policy. The single best way to resolve conflict is to prevent it, and that is exactly the purpose of the deal mediator. As the saying goes, time is money. Therefore, the less time spent on cleaning up a conflict, the more money is saved. Additionally, a good deal mediator will encourage open dialogue and help foster increased communication between the parties, thus leading to a stronger working relationship that will hopefully carry through the entire project. Deal mediation is about more than merely closing a business deal. It is about making better deals that last longer and satisfy all of the parties' interests. Let's face it, who can say no to that? Thank you very much.
Thank you, Claude. Very insightful, trying to maximize value in a deal when, everybody on the table thinks that they have a great one already when they sign up. But how a deal, if you have a deal mediator on the table, you can probably maximize what you thought you had agreed to. And, and now coming to Chitra. Chitra is going to run us through how we look at a transaction process in terms of negotiation and how deal mediation can actually feature and, look at maximizing value, which Claude just spoke about. Over to you, Chitra.
Good afternoon, everyone. Thank you, EMW, for organizing your parliament once again, inviting me and, including a topic such as deal mediation, which is something we need to look at as we, I think this is the next generation of mediation for us in India. What I am going to do is talk about or anatomize what a deal is. What happens, when negotiations over a transaction take place, and why do you need mediation there? I think the why do we need mediation has been explained by Claude, and I'm taking a few steps back to actually talk about what are the concerns and the issues and how do we look at what a transaction is. And in doing so, I'd like to make some distinction between mediations of disputes and mediations of deals, right? So let me start with sort of unpacking what we, the expression deal. I would rather call it, I think it's a very masculine, very power-packed sort of an expression. I'd like to unpack it and use the expression, the building of a relationship. Here are persons who are not making a deal, but are looking at a relationship that they are going to enter into together. And therefore, what is it that, actually transpires, when these discussions take place, and, what goes on behind the scenes, behind the mind of the persons who are trying to make this deal. So typically in a transactions, and I will use 2 or 3 types of transactions. For instance, I will use examples from investment transactions where persons are investing in an existing company, joint ventures where 2 persons come together to start a business, or say a dealership agreement where there is a well-known manufacturer, for example, Johnson & Johnson, who's looking at setting up a dealership at distributing their products in India, and they're looking at a dealer, a person in India who will do this for them. Now, assuming these are persons who are coming together to have a discussion on what their transaction or what their contract is going to finally end up looking at. And what do we see typically in contracts like this or in agreements like this? The first thing we see are questions relating to valuation. How much is this company valued at? What are the products valued at? What am I going to get through this dealership? What are my earnings through this dealership? And what do I want to maximize there? The second is responsibilities or obligations that persons take under the agreement. I will do this. These are your obligations. These are what my expectations are from you. Another aspect that we find in contracts typically are rights. And what this manifests or what it underlies is actually control. How much do I control of what is going to happen in this relationship? Facilitate certain transactions or that require approvals or licenses for certain transactions. In the case of investment agreements or joint venture agreements, there are special protections for minorities. So there is a certain imbalance of power that will translate while the agreement is being implemented by the parties, and how do we ensure that these imbalances are addressed upfront in the contract. The next thing that we're looking at is what is a breach? What could go wrong in this contract and how do we remedy it? What are the kind of remedies we want to make a provision for? What are the different skills that people bring to this relationship? What are the different contributions that the various parties bring to the relationship? And underlying a lot of these issues is information asymmetry. That if it is a promoter who's looking at an investor bringing in funds into a company, there is a lot of information that is evident, that is available in the books of the company, in the accounts of the company, in their minutes, in their contracts that are visible, that are available, that you can read. But there is, like the proverbial iceberg, there is below the tip a lot of information, soft skills, soft information, institutional memory relating to this company that the investor simply is not going to know. And what does this information asymmetry do? It, at the time of making a deal, it makes one of the parties feel uncomfortable, makes a party feel like I need to ensure that I have as much control going forward over this deal or over this relationship, and therefore makes people take positions when we are negotiating the transaction or beginning to get into a relationship. The last is, of course, the dispute resolution clause, which is the law, which is the place we will have, take our disputes to, the courts of which place do we take our disputes to? What is the choice of law? Will it be Indian law? Will it be Cypriot law? What is the dispute resolution process we will adopt? People tend to go to boilerplates in this and say, oh, we go to arbitration and that is going to take care of everything for us. Right? So these are, what I've done so far is to sort of point out the heads of agreement or the talking points that are there in the agreement. You're not going to see language like this in the agreement, but what I've tried to sort of identify are the underlying sort of issues that form the heads of agreement or the discussion points when negotiations take place. What distinguishes deal mediation, or what distinguishes mediations where people are negotiating a contract or beginning a relationship? It's fraught with a lot of anxiety because these are persons who probably don't know each other from before. They are looking at entering into a relationship with each other, and this is going to be a long-term relationship either in terms of the tenor of the agreement that is there or in terms of the long-term implications that will come out of this relationship. In either case, this is long-term, and they are looking at starting this relationship with a person. They are attempting to look into the future and to anticipate and to apprehend what is likely to happen in this relationship. And this causes anxiety. This causes a lot of positional discussion amongst the people, right? So the parties between themselves say, this is what I want out of this. This is the control I expect to have in this relationship going forward. And I want ABCD rights to be available to me, ABCD ways of controlling how this relationship will, roll out to be available to me. So the tendency then is to be positional about how you're approaching the issues when you're negotiating a contract. Unlike disputes mediation where you are looking at the past and then looking into the future, there is very little of looking into the past in deal mediations. You're always looking at the future and looking at the uncertainties, because what looms in your head as a party who is negotiating a contract is, what is likely to go wrong? What do I need to provide for in this agreement, right? So there are also cultural differences. These cultural differences stand out when you're looking at international negotiations. They're very evident there, but they're also very evident in negotiations that take place within a country, right? So you may have an investor who knows, who's only looking at numbers, who's looking at profitability, and who's looking at what returns this person is going to get and what commitments he requires from the promoter of the business to be given to them. So that's a certain perspective that, you know, they bring to the negotiation, and it is a perspective that dominates their discussions in the negotiation. I did speak of informational asymmetries. These do cause a lot of anxieties in how discussions take place. There are also synergies, and which is the purpose behind this negotiation taking place. So person A and person B come and negotiate a contract or a transaction because they have a need for this transaction, right? They expect something, A expects something from B which A does not have, which B is bringing to the transaction, and B is expecting something from A which B does not have, and A is bringing this to the transaction. So how do you modulate, how do you put together these synergies? Is there one of the parties who has a greater need for this transaction or this deal than the other person, right? And this also causes imbalances in terms of power in the negotiation, and therefore, as you know, was spoken by the earlier speaker, the need for a person who comes there and balances this imbalance. The specificities of the transaction, and so when you have a mediator or a deal mediator, you are looking at a person who has some experience in transactions like this. It could be legal, it could be technical, it could be financial, but there is some amount of evaluation that goes along with mediating disputes like this. When I spoke of informational asymmetry, a problem that is there is an underlying fear that parties have about sharing information. Information is power, information is money, information is value, and there is a great deal of hesitation because they believe that if I share information, information underlying why I'm asking for a certain position, it's going to compromise my ability to negotiate. And this is something that is a problem in deal negotiation. Another problem that you have in deal negotiation is the anchoring of discussions on the basis of the first draft of the agreement that is shared. So if party A shares the draft of the agreement, it is the expectation that you need to really struggle to move away from what is circulated as the first draft, right? It's a given. So a lot of discussions are anchored on this draft that is shared. Parties rarely evaluate the upsides and downsides if this deal does not take place. They go on the presumption that if this does not take place, it doesn't matter. But they don't evaluate what are the alternatives, what is the position we would be in if this deal did not take place. And often discussions are unidimensional. I have this requirement, this is the clause in the agreement, and we discuss round and round this clause, right? And how discussions move are incremental, trying to find a buyer media, and it is distributional negotiation that goes on here. There is very little, and the way in which sort of these negotiation takes place are by means of trade-off. I'll give up this, you give me that, right? We also have problems that are typical of negotiations, other negotiations that take place here. The first is the agency problem. You have advisors who participate in the negotiations who are extremely zealous about wanting to protect their client's interests. They want the best for the client and they're adversarial about it. They want everything to be in favor of their client, all controls, all rights to be in the favor of their client, and a loss of control, a loss of rights, an imposition of obligations that the other side must take on. Right? So when you have advisors who are very zealous, who are more loyal than the king, to use an expression, the interest in looking at what are the interests underlying these positions, what are the interests underlying these demands that you're making of the other party, the other advisor, in terms of what they're able to negotiate into the agreement. You find that, because of these agency problems, advisors also often come in the way of negotiating interest-based deals. There are other, problems of negotiation that apply here. The first is that there's a reactive devaluation. If there is a suggestion made by the other side, you tend to look at it with a lot of suspicion. There is, the fact that we are expecting and we want a certain thing to be applied because this is the norm in the industry. For instance, if you look at private equity investments or venture capital investments, a lot of these transactions work on formats that have been borrowed from outside the country. You have foreign equity, private equity investors who've invested in India, who've brought their own formats, and the parties to the discussion are loath to move away from these standard formats that are in the market. So industry agreements are a certain expectation that parties don't wish to move away from. For all of these, the point that Claude made about the need for a neutral to sit with these parties and to discuss moving beyond these positions, moving beyond these insecurities, moving beyond these asymmetries, moving beyond these agency problems, these are the benefits that a mediator brings to conversations and discussions in a transaction. And going forward, knowing what your counterparty's interests were when a certain agreement was drafted, also helps you understand how you're going to move forward. When you know the other person's interests in a particular transaction, moving forward in the relationship after the contract has been signed, you're better aware of how you will work together as a team to implement and to actualize this agreement. Thank you.
Thanks, Chitra. I mean, it's very interesting to note that when we talk about mediation, while we're speaking about mediation, but when you talk about a mediation, when we're talking about a conflict, which is a now moment, where we talk about deal mediation, where we're talking about something that the parties have to live and work with the relationship over a period of time, and hopefully and trying to prevent conflicts on things which Sir mentioned, that, sometimes you had deeper conversations earlier in the contract, you may be able to avoid, issues at a later point. Now, Rahim, coming to you, when you look at things which we anticipate and we look at relationships, and especially in a corporate setup, we have people who are on the negotiating table, then you have people who are in the board. You're talking about people who are employees today who won't be there tomorrow. You have situations will change, you have geopolitics that changes. So when we talk about deal mediation with so many factors which we don't know about at the time when the deal mediation is taking place or the deal negotiation is taking place, how do you think deal mediation sort of addresses some of these concerns?
Thank you, Ekta, and good afternoon to everybody and my fellow panelists.
Is taking place or the deal negotiation is taking place. How do you think deal mediation sort of addresses some of these concerns?
Thank you, Ekta, and good afternoon to everybody and my fellow panelists, honorable judges, and also in the audience. I have received many messages from people I've known over the years, and thank you so much for the kind invitation. Not much that I can add to the extensive coverage that Claude and Chitra have given, but to your question, Ekta, about the different people, the different dynamics in deal mediation, I think one of the most important things that I've come across in deal mediation with regards to this is what I call stakeholder management deal mediation. So this is not a straightforward transaction between two people.
if it was that straightforward, you can mediate a deal mediation. But when you have large organizations doing deals with other large organizations, deal mediation or preventative action and whatever other words we want to use, what this comes down to is understanding all the stakeholders on both sides. So one of the first principles we learn in mediation is to not focus on the people, but focus on the problem. And yet, in a large organization, the people and the various levels of people, so boards of directors and trustees, managers, senior managers, all these roles have a very important dynamic. Because if they don't feel part of the deal, they don't feel part of the structure of the deal, then the deal won't get to the position we want to get to it. So, Hector, to your point, one of the benefits, and I agree with Claude, this is not for any old mediator. These people need to be trained properly, because what is mediation at its purest is assisted negotiation. But in deal mediation, you're not just trying to get to the deal, you're trying to make sure that the deal goes to a place where you also think about what could go wrong. And that requires you to understand all the levels of stakeholder management that are being utilized and invested in that deal mediation. So the thing for me, which I impress upon our delegates when we teach this kind of work, is, do you know everybody coming not just to the table, but is outside the table, but is also heavily invested in the outcome here? So Hector, that's a response I would give at the moment.
Thank you, Rahim. So very important to look at stakeholder management and, feel the need to be part of a deal, because otherwise it's in silos, where you look at it again very positionally, then rather than getting into the different stakeholders and seeing what their interests are, which makes deal mediation success. And I'm going back to what Claude is saying, and my next question is actually part of the deal. You feel that I can do it myself. And lawyers, in my experience, we tend to be very positional. And adding to what Rahim was talking about, we need to look at stakeholder management, and then tying it to what Chitra was saying is that we need to also look at the future, and we live with boilerplates. So as lawyers today, are we prepared enough for deal mediation? And in your view, what are the skills that we need to have, and how should lawyers view deal mediation and their role as an integral party to the entire transaction itself?
Ekta, I'm sorry, the question was for me or for Aman?
Our question is to Aman.
Thank you very much. I thought it was for Claude, since you mentioned for Claude. Well, before I come to what the lawyers, how they should approach it, I've been hearing this conversation, it's very interesting. You see, I think involving a third party to build together a best possible a solution or a deal, or as Claude had put it, or trying to build a relationship, as Chitra had put it, or stakeholder management. Of course, the lawyer has a role, but all these have been done for ages. So when we talk about deal management, we're talking about it's slightly different from deal mediator. What I would like to build on is the most excellent overview, which has been given by Justice Jain, as to what is mediation. I'd just like to go at a slight divergence from what has been discussed so far. I'm not for or against deal mediation. Of course, it has its advantages, which you've just heard very eloquently. The mediation regime domestically and internationally does not recognize such transactions as part of mediation. Whether it should or should not is a different issue. But if you see the current regime, it does not. For example, if you see, we talk about India, if you see the mediation rules which were considered by the Supreme Court, it presupposes, as Justice Jain put it, that there has to be a dispute. Rule 16 says the mediator shall attempt to facilitate voluntary resolution of the dispute by the parties. So there has to be a pre-existing dispute. If we talk about the Arbitration Conciliation Act of 96, the role of a conciliator, the conciliator shall assist the parties in an independent and impartial manner in their attempt to reach an amicable settlement of the dispute. So there has to be a dispute. If we talk about the mediation bill, mediation shall be a process whether referred by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby parties or party request a third person referred to as a mediator or mediation service provider to assist them in the attempt to reach an amicable settlement of a dispute. Again, it presupposes a dispute. Even if you see the international level, this definition was borrowed from the Singapore Convention. Even Singapore Convention defines in section 1 subclause 3 mediation in context of a dispute, and so does the ICC rules. So the current regime, nationally or internationally, presupposes a dispute. That does not mean, so that is the point one is, we are thinking of doing something which is outside the current regime. And
Amar, are you able to hear us? I think while we wait for Aman's back.
yes, so the neutrality element is there. The mediator cannot, as was pointed out, cannot give opinion, cannot decide. So there's a principle of party autonomy, self-determination. The deal mediator is supposed to remove the power imbalance, we have just been told, manage the negotiation process, shift the parties from the positions they've taken to the underlying interest. All these are skills of a mediator. Even preventive management to prevent an impasse, again, so skills overlap. So why should mediation not include deal mediation? So that is a legitimate issue. And I would simply call like I said, I'm not for or against it. I just think we need a wider debate. Because today what is happening is we anyway are struggling with the issues of how to bring about accountability, standards, quality control for mediators. For those of you who are aware of the current dispute or current debate on this, there is a debate about, is mediation a practice of law or is it only a practice of law? Because anybody can be a mediator. Now, when you're gathering information, asking people to respond, there's an element of proving a fact, there's a reality check, the Vatna, which you talk about, a mediator gives suggestions, gets clarification, all that is a practice of law. But is it only a practice of law? Because once you have different roles of the third neutral party and of the parties which are from legal background, theoretic background, economic background, construction background, hotel management, as Claude, I'm told, is the different problem-solving disciplines. And the result is not a win-lose situation, but to get the best deal, which is premised on the underlying interests of the parties. So it is not, mediation is not only a practice of law, it is much more than a practice of law. Even there, with the existing regulatory network or existing regulatory framework we have issues of maintaining neutrality. For instance, parties seek substantive expertise or repeat players to be mediators. Somebody is very good in IP, somebody is very good in environmental law or environmental issues. A party may say, well, we want them to be the mediator. But that repeat player may know one party better, so neutrality gets compromised. Similarly, when you're trying to remove power imbalance, you're trying to reduce inequality, so you're exchanging neutrality for the fairness of the process concerns. Now, for deal mediators, these issues become aggravated. If a deal mediator has been a deal mediator with a party A or company A in several deals, he's likely to get to be more familiar with party A than with a person or the other party with whom he's never had a deal. So these are concerns which need to fly. We can't simply dismiss these concerns in the Bar Council. Those rules don't apply. But a mediator, much less a deal mediator, is not a lawyer or representative of a party. There's no loyalty concerns, which is there traditionally for a lawyer. But even if that lawyer deal mediator is participating, people will get influenced by what that person is saying. So even within the existing setup, there's a debate which is going on in India as well as in other jurisdictions as to we need a mechanism for accountability, mechanism for quality control, mechanism for standards to be maintained by mediators. Who's going to regulate it? Is it the Bar Council? Is it the courts, implying that mediation is a practice of law? Will there be transdisciplinary regulation of other professionals? What if different professionals suggest different treatments for a particular problem? As a lawyer, mediator, he cannot solicit work, he cannot advertise, but a chartered accountant deal mediator can do so. There's a turf war. Do we need a multidisciplinary standards to be laid down? In India, what is really taken off is court annex mediation. Should a mediator or misconduct himself or herself, the remedies to all disempanelment and that settlement agreement can be challenged as being obtained by fraud. The mediation bill also lays down grounds of challenges of a mediated settlement agreement, which is a decree of a court. What if a deal mediator misconducts himself or herself? Or the outcome is a contract. That contract will be vitiated. Now, would that deal mediator be exposed to criminal action? Will that deal mediator have to pay damages? What happens about the confidentiality? There can be several issues which we are looking at, which we need to flag. So which is the reason why I say that I'm not for or against mediation, including deal mediation. Of course, this has its advantages and benefits to prevent conflict. You save time, you save money. You are able to reduce, if there's less disputes, less burden on the courts. So preventive is obviously the better cure. There's no dispute on that proposition. But before rushing in to include deal mediation within the legislative framework of mediation, we would need to thrash out and brainstorm many of these issues. So that is keeping track of the time, Ekta. So I think I'll stop here. And of course, if somebody would want to, if anybody would like me to expand on any particular aspect of it, I'll be happy to do so.
Thank you, Aman, for highlighting whether we need deal mediation to be regulated and whether there's a requirement to look at it from a multidisciplinary approach as well. So before I open it for questions, one question, and this is open for all. So when Sir started, the introduction as a chair, you said, we'll have mediation where parties will resolve issues and there won't be a need for conflicts at a later date. But I think conflicts are a part of life. And, while we look at deal mediation, reducing the number of conflicts or getting the parties to engage and have more clarity when it comes to conflicts, my question is that, do we see when parties have participated in deal mediation, do we see a change in behavior when they look at conflicts during the course of the transaction itself, and as well as how they would approach a conflict and their willingness to mediate conflicts if and when they arise? We can start with Rahim and then move on to Claude, Aman, and then Chitraji, and then Sir, your concluding remarks after that. So,
Ekta, would you mind just repeating that last bit? I was disconnected then.
So sorry. So when we look at deal mediation, parties, with your experience, when the parties have gone through deal mediation, would you see a change in behavior or how they will look at and approach conflicts during the course of a transaction, and therefore their willingness in case of a conflict to take the path of mediation more naturally, rather than an adversarial
Yes.
in terms of how they look at disputes per se, whether bilateral negotiations or mediation, how would you think about they would approach conflict?
So organizations that participate in this kind of preventative mediation, deal mediation, really getting stakeholder management, I call it. What they tend to then become is proactive dispute resolution participants. So they look out for the opportunities of problems and prevent them much, much earlier. You know, this idea of escalation clauses in a contract, dispute resolution clauses, where you negotiate, you mediate, you arbitrate, etc. Well, what these guys do will say, well, we'll have all of them, but actually what we want to do is get back to the table, resolve this quickly, and move back to a relationship which continues. They're not interested in the arbitrations and the litigation. So they become proactive managers of conflict resolution. And you will see the organizations around the world. I don't want to mention any names right now, but we're talking some of the biggest organizations around the world who have now moved their ethos from a combative legal team and negotiation team to a much more preventative, resolution-orientated, dialogue-orientated team. And these people have reduced not only cost, but have improved their relationships with their clients. So you're seeing a massive development in this area.
Thanks, Rain. Claude?
Well, Rahim said it all. So I will reply your question, Ekta, with a life example. I have a friend who has 3 brothers. The 4 of them are entrepreneurs. The 4 of them hold 25% each of the kingdom their father, who is one of the best entrepreneurs in Europe, has built over the years.
And my father assists. Whenever there is a dispute, my father makes the decision. Everything goes well in the family. We are very happy
There is a dispute, my father makes the decision. Everything goes well in the family. We are very happy and favored family. We would like your help to schedule for when my father, our father, will not be with us anymore. So we decided to meet for 2 days in a castle outside of nowhere. No phone, no nothing, no television, no nothing. The first day, we met with the 4 brothers. The second day, we invited the father and the mother. The most critical point of the first day was, let's say your father is not available. How do we make decision? We have 4 shareholders of a holding company, 25% each. So they said, if 3 of us agree, we have 75%. That's enough, isn't it? I say, in theory, yes. How about if 2 of you agree? If we have 50-50, then we are at impasse. We take the decision that is the closest to cash. I say, why cash? Because cash is the safest haven for the holding money. I say, what about if the interest rate at 20%? Isn't getting 20% safer than getting nothing? Anyway, to make a long story short, they, the 4 of us, decided that whatever the decision, they need a consensus, whether it will take 1 day, 2 days, 3 days, which was a very strange decision because it may sometimes be quite difficult to get to a consensus. Then they said, we won't leave the room until we have a consensus. We will reduce the amount of food from day 1 to day 2, from day 2 to day 3, from day 3 to day 4, but we will not leave the room until we have a consensus. And I said, look, my job is to ask the most stupid question. What do you do if you cannot reach a consensus? Then with a big smile, they said, we call you back because we enjoyed this conversation very, very, very much. That was day 1. Day 2, The father pretends he wants his son to run the show, but he is so much of an entrepreneur that he is always in the middle of making every decision. He had breakfast with me face to face, and he asked me, "So where did you get yesterday?" I said, "I don't want to disclose everything. We want to do that in a plenary session. But what I can tell you is I admire your four sons, because their decision was to go for a consensus." He looked at me with a big smile and said, "Let's play tennis. We don't need to meet." So that is the lesson of deal mediation, or let me put it differently, an illustration of what Rahim just said. By giving them this opportunity to understand how it works, you have educated them. And most of the time, they won't need you anymore because they have a complete different approach to their business, to their decision-making, to their relationship. And they look at it in a proactive, more creative way than they were doing 48 hours ago.
Thank you, Claude. Aman, any thoughts on that?
Well, very briefly, yes. Those who have been through deal mediation, I just feel that the communication channels are better. I mean, people are willing to communicate, reach out to the other person once they've gone through a relationship or a deal in which the underlying interests of both sides have been satisfied. So they're more happy to communicate with each other. And I think there's also a comfort factor that there is a third person they can fall back on should there be any misunderstanding or they need to have some clarification, something a person can't really dare to ask the other person directly. They feel they can route it, some apprehension, they can route it through the third person who had acted as a deal mediator. So on both fronts, communicating directly with each other, as also routing it through the person who had in the past been the deal mediator. That element is quite prominent once there is a deal mediation, as opposed to contracts which are directly negotiated between the parties based more on positions than on interests.
Thank you, Manchitra.
I think all aspects have been covered. I'd only probably add the point that I think people will be more alive, contracting parties will be more alive to even differences as distinct from disputes that might crop up. Be alive to it and be open to discussing it on an interest-based way. And I'm sure that we will find mediation provisions in their dispute resolution clause in the agreement. Thanks.
So we leave the concluding remarks to you, sir.
Ma'am, if you remember, I start my talk with that conflicts are inevitable in our life. We can never avoid conflict. What I understand, you want to ask the impact of deal mediation on the future contractual behavior of the parties, right? This is the, I think, the basic spirit of your questions. One thing I would like to say is that what literature I have read on the deal mediation, it is taken to be the facilitative negotiation. I was just discussing with Madam Chitra, this deal mediation can never be facilitative negotiation. It can always be evaluative negotiation, because at that time we will be making the assessment on the facts and the law and the possible future relationship between the parties. I don't think there is any scope of further facilitation between the parties. If the deal mediation is conducted in the right perspective, if the real issues, real concern, real interests of the parties are addressed properly, I think in the future we cannot avoid the dispute. We cannot avoid the conflict. If we have gone through the phase of deal mediation, it doesn't mean that there would not be any conflict in the future out of the contractual relationship. Disputes are bound to be there, conflicts are bound to be there. But as Madam has said, there would be the more positive atmosphere to address the conflict, to resolve either in a traditional way or in a creative or innovative way. The parties, they would be more and more open how to address their future conflict relationship, because we have, by way of deal mediation,
we have provided only the little bit prevention to the future conflict. But we cannot say the future conflicts are properly and permanently cured. This cannot be said. So the atmosphere would be totally different, no doubt about it. If the deal mediation is done by a right person, a trained person, or a person who is having the deep knowledge how to do deal mediation, because litigation mediation and deal mediation, what I understand now after hearing all the experts, both are different. Because for pre-litigation mediation or post-litigation mediation, the existence of conflict is precondition. It is condition precedent. But for deal mediation, it is not required. Existence of dispute or conflict is not required. But definitely party would open with a very positive mindset, positive attitude. They will be more prone for resolution because their prime interests have already been addressed at the earlier stage of deal mediation. So you are right. Definitely there would be change in the contractual behavior of the parties if there is deal mediation in the past. Thank you.
Thank you so much. I thank all the all the panelists. It was a very engaging session. And I think when we look at deal mediation, apart from the fact that you'll have a robust contract or a robust transaction where interests have been discussed, it also looks to change a behavior of the parties itself when they look at, conflicts and differences. And as Chitra mentioned, you become alive to differences. And, you'll be open, and as, Aman and Claude also said, they'll be open to communication. We'll probably see more mediation clauses coming in. It's preventative. Parties will be more proactive in terms of how they look at differences as and when they arise. So when we look at deal mediation, it's not just about the deal. It actually gets into the behavior of the parties during the entire transaction or the contract itself. With that, I'll open it to questions.
One thing, but just one line. But I can say deal mediation yet to be tested in our country.
Or if it's tested, it's yet to be reported. Any questions that we have for the participants? Yes, we have a
Actually, hearing this is a very interesting experience. I am new to deal mediation. It looks very romantic, but there are certain legal issues. Wearing my lawyer's hat, I can straight away find. Let's say there's a tender. Are you talking about the deal mediation post the award of tender or after the contract is negotiated? After the contract is being performed during the process. If you are doing it post tender, sometimes an issue may come that you may change certain conditions, and other people may challenge that bidding process, saying you have changed it post-tender. One. Second, suppose during the process of performance, certain issues come and certain terms are changed, or at least certain terms are agreed upon. Then Section 91 and 92 of the Evidence Act come to bar, oral arrangements, unless it's again you have mini contracts. So there are several legal issues that arise. So I think before going into deal mediation, we need to think through the legal provisions and implications before kind of jumping headlong into it.
Just I mentioned, sir, that deal mediation may have color of the evaluative mediation also, negotiation also. At that time, we are supposed to assess the parties' position on facts and law also. If the legal issues are involved they may be involved in the past, may involve in the present, may involve in future also, as you have just mentioned. Those can be addressed at that time. But what could be, what would be, what should be the future conflict, it cannot be well anticipated in advance at the time of drafting the agreement. So what we mean to say that, as Madam Mehta also mentioned, that the contractual obligation and contractual behavior can be altered if we undergo the process of deal mediation in a more positive and more productive and more pragmatic manner also in future also. That we mean to convey to all of you. Legal issue of a problem is a purely legal, then it has to be addressed by the court, not by the mediator in any form.
Giri, thanks for those points. I do agree that, and I think it was implicit in the discussions that these are discussions leading to the execution of a contract, negotiation of a contract, and therefore, where there has been a tender and bids have been made, and a certain bid is selected and the contract terms are renegotiated to probably, the disadvantage of other bidders, I don't think it's a possibility. This is a bilateral negotiation that we're speaking about. And the second is, if following the contract, there is mediation and the terms are renegotiated, that would be a novation and recorded as such. So 91, 92, I think may not apply. I mean, thanks.
Any other questions? So there are no other no other questions, and I'm still in my contractual. We'll end the session. Thank you so much to all the panelists. I really enjoyed the discussion. I hope everyone did too. Thank you.
Yeah, thank you, and many, many congratulations to EMW, Mr. Tankachan, to Rima, Push, to everyone for this, and to EMW for the 3rd anniversary. Thank you for inviting me.
Thank you very much to all. Thank you, Push. Thank you, Ekta. It was a pleasure.
Present. I'd like to extend our heartfelt thanks and gratitude towards our chairman and panelists. We sincerely appreciate your invaluable contribution and words of wisdom. I'd firstly like to thank our distinguished chairman, Honorable Mr. Justice Dr. Sudhir Kumar Jain, Judge, Delhi High Court. Sir, your nuanced insight towards deal mediation was rather enlightening. I request Ms. Revati Ganesh Mohan, State Coordinator, EMW Tamil Nadu, to kindly felicitate Sir with a token of our appreciation. Thank you, ma'am. Moving on to our venerated panelist, I'd like to thank Ms. Chitra Narayan, Advocate, Senior Mediator and Mediation Trainer, Chennai. Thank you, ma'am, for sharing your valuable perspective towards the topic at hand. Your wisdom and experience has definitely enabled everybody here in understanding deal mediation meticulously. I request Mr. Suresh PG, State Coordinator, EMW Kerala, to facilitate ma'am with a humble token of our appreciation. Thank you, sir. I would also like to extend our gratitude towards our reverenced moderator, Ms. Ekta Behel, Advocate and Mediator, Partner Samvad India. I request Mrs. Rima Bhandari, Coordinator EMW Delhi, to kindly facilitate ma'am with a token of our appreciation. Thank you, ma'am. Last but certainly not the least, I would like to extend a heartfelt gratitude towards our panelists online for virtually gracing this distinguished gathering. Dr. Aman Hingorani, Advocate and Senior Mediator, Supreme Court of India. Mr. Claude Amar, I hope I'm pronouncing that correctly, Managing Partner, Mediation and Resolution France. Mr. Rahim Shamji, Founder and Chief Executive, ADR, ODR, International, United Kingdom. Thank you.
We will break for tea for 15 minutes and come back for the panel discussion on online mediation. Thank you. I request those who have not received the certificates to collect the same from the right corner of the stage where the mementos are kept. Certificates are there. Those who have not received, please go to the counter there and collect your certificates. seated.
Hello? Yes. Okay. Ladies and gentlemen, if you can please take your seats, we will begin the third panel discussion for today. Please feel free to bring your tea and coffee inside the hall. We're very happy to make this a Chai Pe Charcha session in that sense. We hope it'll be a little interactive. All right. Well, welcome back, everybody. Our speakers for today include the distinguished Justice Mohammad Mustaq, Judge of the Kerala High Court. We have with us Ms. Chittu Nagarajan, founder of ODR.com, Mr. Vivek Goyal from Wonderbots. We also have Ms. Namita Shah, founder of Presolve 360. These are all pioneers in the ODR space. E-justice, expanding access to justice, and that really is the theme of our panel, which is online dispute resolution and artificial intelligence. The words ODR and artificial intelligence carry with them a lot of promise. The idea, of course, of alternate means of dispute resolution itself is expanding access to justice and adapting that to online mechanisms and the internet makes a quantum leap, the ability for us to leapfrog so many barriers to access and radiation, which is how do you add value? Where does artificial intelligence come in towards expanding the pie of justice, towards increasing accessibility for everyone? We hope to explore some of these themes in depth. Now, before we jump into that, it would be my honor and great privilege to introduce to you in detail all our speakers for today. To start with, our session is being chaired by Justice Mohammad Mustaq. Justice Mohammad has been a judge of the Kerala High Court since 2016. And in fact, he headed and continues to head the E-Committee of the Kerala High Court. Not an easy task, especially with the onset of COVID and the pandemic. So his lordship has been intrinsically linked with delivering justice to the people and ensuring access for everyone. Engagement with the digitization of the courts is no small matter, and today we're here to see how online dispute resolution mechanisms can go ahead and complement this. His lordship has been connected very much with the roots of ODR as well, because he had in the past done an advanced course on e-commerce and intellectual property from the World Intellectual Property Organization. Beyond that, Justice Mustaq is, of course, a trained mediator. He had mediated for many, many years at the Kerala Mediation Center and also served as faculty and trainer for IIAM. Sir, it's a pleasure and privilege to have you with us today. We also have with us very distinguished members joining us from the US of A across two different coasts. So thank you very much Mr. Daniel Rainey and Anna Sambold for taking the time for being with us today. Daniel Rainey is the principal at Holistic Solutions Incorporated. He's a fellow of the National Center for Technology and Dispute Resolution at the University of Massachusetts Amherst. He's also a founding board member of the International Council for Online Dispute Resolution. It's a pleasure to have with us today an academic who pioneered and delivered the first set of courses and curriculum on online dispute resolution. Today, he's also the co-chair of the International Mediation Institute's E-Mediator Competencies Committee, a dedicated ethicist as well as the mediator. He works with the Supreme Court of Virginia's Access to Justice Committee and very often reviews codes of ethics and practices for mediators across the board. It's a pleasure to have you with us, sir. Complementing Mr. Daniel Rainey, we have Ms. Chittu Nagarajan here with us in person, who has pioneered the development of online dispute resolution for over 20 years. She as well is a fellow of the National Center for Technology and Dispute Resolution, Amherst. She's also been a founding board member and the immediate past president of the International Council for Online Dispute Resolution. Ms. Chittu, of course, wears many, many hats, foremost of them being a serial entrepreneur who's founded ODR.com. She's been the co-founder for Crec ODR and Modria. And not to forget, she of course headed the eBay and PayPal Community Courts Initiative. We have with us, of course, Ms. Namita Shah. Namita is a pioneer and leader in the Indian space of online dispute resolution as a founder for Pre-Solve 360. Pre-Solve 360, as the name would say, is a way to promote conflict avoidance, similar to the ideals of deal mediation that we previously just discussed. Namita is a gold medalist chartered accountant who then studied the law, and she's also served as a guest faculty at MNLU Mumbai's MA in Mediation. It's a pleasure to have you with us today, ma'am. Thank you for being with us. We have with us also Mr. Vivek Goyal. Mr. Goyal is a consultant at Wonderbots, and of course, everybody wants to know what is it that a consultant actually does. Well, Vivek works in digital and business transformation, and to narrow this down further, he specializes in the automation of code or low-code platforms. So today, when you hear about all the magic and wonders that ChatGPT does, he's the guy to ask as to whether that's going to take our jobs away or not. It's a pleasure to have you with us, Vivek. Thank you for making it here today. Last but not the least, we have Ms. Anna Sambold. Anna is the chair-elect of the Dispute Resolution Committee of the American Bar Association, an active and skilled mediator. We look to her as a mediator based in California to understand the competencies of engaging with new forms of technology and artificial intelligence. Also a multilingual mediator, we hope to get insights on how a mediator can engage with parties across language differences, cross-cultural differences, and the role that technology and artificial intelligence has to play in the same. It's a pleasure to have you with us. With that, these are all your panelists today, and they are most welcome. I now hand over the dais to our chairperson, Justice Mohammed Mustaq, to deliver his opening remarks. Thank you.
Thank you. My esteemed brothers, Menon and Suthir, the fraternity of mediators across the country. It's a pleasure to address all of you. Well, I took a vow yesterday that I will not eat sweets because I regained some weight last month. After my Ramadan days, I shed a lot of weight. But during vacation, I had attended so many conferences. I tend to eat a lot of sweets. So I took the vow, said I'll not eat sweets today. When I met Javed today morning, he said I asked him how many kilos he shed. He said he lost 8 kilos because he stopped eating sweets. So my spirits went in high. Today during lunch, they brought some local delicacies. What is it? Damak, a double damak or something, and another one. So I was very tempted to eat. And I looked at the table of Jawad. He had he's taking, I saw he's taking the sweets. Then I thought, why should I stop? So I also took the sweets. I related this. I also want to relate to the mediation. We have been talking about mediation, but always ultimately come and bog down to the relating mediation to dispute resolution. This is where we get wrong fundamentally. Today also the Honorable Governor and Sriram Panchu spoke about mediation in different level rather than looking in terms of minuscule area of dispute resolutions. In any conversation, any discussion, whatever we talk about mediation, we just settle it with the dispute resolution. This is a fundamental error we commit. We need to change ourselves and our thought process. In contextually, of course, we relate to dispute resolution, no doubt. We call it as sometimes a deal mediation and dispute resolution. We use it as a tool. After all, mediation is all about, it's an approach, nothing else. It's an approach. In Kerala, we face a peculiar problem now. Many headlines you might have seen, human and animal conflict. Rogue elephant called, of course, any animal lovers, pardon me, I call it as a rogue elephant, tusker, Marigold. It eats rice. So it killed many. It was a big problem for in Kerala. The government thought to rehabilitate and keep it as a captive elephant. Animal lovers approached Kerala High Court and thought Kerala High Court that should be the last resort and it should translocate to some other place. This is now with Uma Narayan and Jawad in Tamil Nadu. Now it created another havoc in Tamil Nadu. I think I saw the news that it killed another person. The problem is here, understanding the animal. If our statesmen given the proper training in mediation to understand others, an approach would have been different. A conflict of this nature could have been avoided. It reaches, the animal comes to the human inhabitants because it loves to eat the rice. Animal lovers thought it being captured as a captive elephant and denying its freedom. And we ordered to translocate to some other place deeper in the forest. Mediation is all about understanding, including an animal. And take approach or steps or decision, action in accounts to what others needed. That's what I said, it's an approach. It's all about approach. Maybe the animal will not come to a table for a discussion. But those who are taking a decision will be in a better position to take a proper decision in the interest of all, including an animal. So why we are talking about mediation and related to dispute resolution? It can also give certain kind of relief to the animal also. It's possible. Another problem we face in Kerala is typical, the conflict between doctors and patients. You see that every day that a doctor been abused, manhandled, mistreated, ill-treated. So many news, and recently when a young lady doctor was killed. Of course, that is a different story. He was under influence of drug or alcohol. Why this is happening in Kerala? I come from north of the Kerala. It's called Kannur. It's very close to Karnataka. It's Mangalore. People used to go there in Mangalore to consult doctors. They are quite happy with the doctors in Mangalore. Elisa might be knowing, she's from Kanangad. They know because their approach is totally different. Not that their, competence level is high and Kerala doctors' competence level is much less compared to them. But problem with doctors in Kerala is they hardly communicate with the patients. They never understand what patients feels about it. If the doctors are given proper training on mediation, I'm not saying the exact mediation what we do in dispute resolution. Idea of understanding someone and communicate properly to them, this issue can be resolved. So I referred this. You don't relate mediation to dispute resolution. If you relate mediation to dispute resolution, that's a fundamental error we're going to commit. We talk about mediation and there exists in our culture. Yes, it exists in culture, not as a dispute resolution. It is in a value in our approach. Unfortunately, today we practice mediation as borrowed from Western thoughts. This is a mistake we committed. Of course, it has its own highlights and differences. We may have to use it in different context. But when we want to boast about mediation, we need to think about it as a value within our culture and tradition and make a different approach to that. Why I want to highlight this issue in the ODR. When you're speaking about ODR, we also commit same mistake. Why ODR becomes so important in dispute resolution? Of course, if we confine to dispute resolution. ODR is what? Nothing but an ADR on the online platform. We may tend to think, create a platform in a virtual mode, creating a platform like whatever they resolved in many other startups now engaged in making a virtual platform very conducive for negotiations, recording, even drawing a settlement agreement, etc. But in ODR, the only place we can make the idea of mediation different level, transformative level. How is it possible? That's where our thought process should lead to us. In this discussions. We hardly thought about using private international law. Private international law is not an international law, it's a domestic approach to an issue of having a foreign element. When our country is boasting about digital economy, actually it's thinking about advancement of our GDP or growth in GDP in terms of economy. What kind of support we can give? An impetus for our growth in economy. How e-commerce should shape. In fact, eBay and all started initially as for their support to the commercial activity, the dispute resolution, they evolved it. How we can think about transforming dispute resolution online using private international. Today we have a really robust system in arbitration for the reason that New York Convention, Geneva Conventions, ultimately it's, of course, model law made by UNCITRAL. These conventions evolve a consensus. And intergovernmental agencies involved in this and agrees on terms regarding on choice of law, rules of procedure to be followed, and enforcement. As far as in mediation is concerned, of course, the two aspects may not be relevant, but as far as the question relating to enforcement is more important. Then mediation becoming a transformative level for boosting our international trade. Why people are not, reluctant to have a much transaction across on the virtual platform for the reason that there is no, of course, it's possible to hold mediations or negotiation through online, but when it comes to the enforcement, it's a difficult area. Unless there is an agreement or understanding of different governmental agencies for enforcement, it is not possible. So we need to think about private international law implications, and we need to work on it. Like EMW, when you're promoting mediation in the country's interest, you also need to create a working group for that, so that we can push intergovernment agencies. There are many international bodies which would take your suggestions so that there can be an enforcement. In the European Union, it is happening in online dispute resolution, consumer matters of certain monetary claims. The union members would enforce it. Such an award passed by an online medium. There is no difficulty for it. Many imports are coming from China, many imports are from other countries coming to India. Or we also export it. But what kind of a support system we are going to give it? So when you're talking about ODR, we need to think about something else. Voluntary process and settlement, but most important part is enforceability. If party is not honoring the agreement, there is no difficulty giving a binding nature of online agreement because of the provisions of the IT Act. It says it is having the same force of a contract. But where exactly the enforceability? So group like this need to have discussions on private international law. So it will take the mediation at next level for acceptance, and more it will give impetus, it will give support to a commercial activity which takes place through online. Another aspect of artificial intelligence, yes, this is again another area where we need to have a lot of discussions. How AI can help us. As a neutral, mediator, of course, we say that we're neutral and if you only facilitate. And of course, I need to distinguish between mediation in which there is an element of personal relationship and non-personal relationship. In personal relationship, it is always we go for a offline mediation because a mediator and parties create build a relationship, and that itself would facilitate a settlement. But it may be difficult in virtual platform to build such a relationship because both are in animated situation and their platform. But still we can use it because large number of immigrant population we have, especially in Kerala and Chandigarh, they have a large number of migrant population living abroad. They can use it. But there are advantages of using AI tools. If a mediator cannot, he can only facilitate, he cannot even evaluate in our context. But when a party speaks up from their bottom of mind, the machine can understand your problem. Machine can evaluate your problem. Machine can have a caucus with the party and say that where you stand in your position. And if you go to ultimately litigation, you have a chance of losing or winning the lawsuit. Today, you all know the ChatGPT, what ChatGPT is doing. All the data being evaluated and give a predictions. In same manner, when a party in a mediation process, an online process, picks up a mind, and machine hears both sides, machine can evaluate. If a mediator evaluate, it's related to ethical part of the mediator. But machine evaluate, no one would make an attribution because machine has no personal element in it. So it's quite possible for a machine to evaluate in the structure we make and give inputs to the party concerned. In second aspect of AI, all you know that machine has learned all languages. The biggest hurdle for all of us is a language, especially in mediation. A Telugu speaking person may not know that what Bengali conveys to him. or it's vice versa in Tamil or Hindi, Malayali and other languages. The biggest hurdle for all of us in any negotiation or understanding the others is the language. Language become a big barrier. They would make easy. Whatever language you speak, natural language, can easily convert it in a language which is known to you. That is the biggest advantage. So all the barriers exist in the physical form. In mediation, that is being lifted. This is only possible in online. Of course, in physical also it's possible that it can translate and give an idea. But this makes mediation quite easy. The transaction tools, if you can look at it, our development in India is achieved. Whether in the official side, Bhashini, Anuvantani and many other, there are a lot of agencies are involved in language translation. And in real time, it can convey to other side the language which he is familiar about what other speaks. So this is one area where if we use AI in a proper way, help and mediation. If we want to have a transaction with the Chinese and Indian and Chinese can have a negotiation or a mediation through using these tools. There is no barriers of language. Language has been always a problematic, especially in Indian context, because each state has been constituted based on language. So that issue of languages vanish in the online platform. So AI can help us and promote mediation. So in conclusion, we being primarily lawyers and legal professionals, we tend to relate mediation with dispute resolution. We should stop that mindset. Mediation should reach in such level where everyone should have an idea. Our statesmen, our police, our doctors, our engineers. So its impact is felt in the national level or in larger interest of the society. That will bring the peace for everyone. Thank you one and all.
Thank you so much, Your Lordship. I'm hopeful that we will be able to unpack some of these themes in a little more detail throughout the course of this session. Anna, welcome. It's such a pleasure to have you with us. Now, in mediation, it's quite common to know that we have to keep the process moving forward. We have to shift parties from their positions and help them understand their interests better. So in other words, we need to know where we are to understand where we want to go and how. So keeping that in mind, I'd like to ask you, Daniel, if you could kindly really walk us through the history and the origins of online dispute resolution so that then we can better understand the next frontier we're exploring with it, with artificial intelligence in the mix. Daniel, over to you.
Systems over time. version at the time, and creating disputes at a level and volume that we hadn't seen before. So literally hundreds of thousands and millions of disputes per year, and making it impossible to handle those disputes with face-to-face mediation, face-to-face intervention. Now, the term MDR touched on the confidence in the United States in the mid-90s, where the question was, how do we deal with these disputes that are
found was that judges who did not use the artificial intelligence, did not use the suggested sentencing from the AI, were less biased in their approach to sentencing than the judges who did. And the reason is that they did a perfectly good job of creating the data set for the AI. But what they had done is go back and pull all of the sentencing records from the past in the courts, which were themselves biased. And so the AI was simply passing along the bias in its suggestions for sentencing. Excuse me. The same thing applies in anytime you're going to use it for private practice. If you're doing divorce mediation and you want to find a way to suggest an outcome to the parties, and you have a database that the AI has learned from that is all the divorce settlements in the last 10 years, then it will go in and pull out information from that from what it's learned. And if you created the data set well, you get good answers. If you created the data set badly, you get bad answers. So I guess where I'm going with this is that one of the things that has been an issue from the very beginning in online dispute resolution is how do you think about the ethics and standards of practice for mediation and for online mediation that will ensure that there's fair treatment and that there is utility in the work that we're doing. And the National Center for Technology and Dispute Resolution and ICODER have published standards which we think are going to be adopted pretty much wholesale by the International Standards Organization. And there are 4 of them that I think we need to think about as we talk about online dispute resolution and AI going forward. And those 4 are accessibility, accountability, fairness, and legality. The reason I think those are important is they speak to how the AI is created in terms of the data set from which it learns. What I'm quite sure is going to happen over the next couple of years is we're going to begin to see a lot of targeted AI programs that are on the market. And so if you do divorce mediation, there's going to be a divorce mediation AI. There's more than one probably. So we're going to begin seeing these systems come out that we are going to have access to and are going to be available to us. If we insist that the essential best practices and standards that drive online dispute resolution, accessibility, accountability, fairness, and legality, if we insist that those are part of the transparent approach to developing the AI, then we have a chance of having usable AI that is at least less biased than it would be if we didn't pay attention to those things. We've already got at least one online application for mediation in which ChatGPT has been incorporated. Next Level Mediation does this. There are probably more by now. But we're going to begin to see more and more of this. But I think the message that I would give to mediators and mediation organizations and arbitrators and arbitration organizations and legal organizations is this: be loud as you begin to see these products come along, as you begin to see the AI that's available to you. Basically try to hold the individuals who are creating those applications to the standards that you would hold yourself to if you were operating as a human being doing this work. So it's a commercial interest, essentially. If I'm a developer and I want to develop a product that is going to be used by mediators of the courts, if the people who are involved on the user end say to me, here are the standards, here are the things that we want you to use as you create this AI. And if you do that, if you're transparent and you create accessible, accountable, fair, and legal systems, we will buy your product, we'll use your product. If you don't do that, if you're not transparent about that, we won't use your product. That is the best way, in my opinion, to regulate the development of AI for mediation. There are basically 2 approaches that are sort of running parallel at the moment. One is de jure approaches to regulation and creating guardrails, and the other is a standards-based approach. The de jure approaches, in my mind, are limited in venue. It's sort of the same problem you get with using the AI to give you information or give you advice about legal issues in a particular venue. AI may give me a great approach that would work in one jurisdiction, but would not work in the jurisdiction where I happen to be working. So if we're diligent on the front end. And instead of passing laws in each country to regulate AI, take a standards approach and say, look, we know what works, we know what's fair, and we know what makes online dispute resolution acceptable and workable outside of AI. And if you take those principles and you're transparent about how you transfer those principles in terms of standards, then that works across borders. Because we're talking there about high-level principles as opposed to laws which are passed and then are very narrow in scope. So it's interesting to talk about the development of artificial intelligence in mediation, because there's an assumption on some levels that it's new, but it isn't really new. We've used very simple AI to work side by side with mediators really from the very beginning. The only difference that we have now is that we're moving out of that bounded universe where it's a very straightforward process. And we're saying, look, we're going to invite AI into our messy process. We're going to invite AI into these complicated things that we do. And it's much more important for us to keep our eyes on the notion of fairness, equity, accessibility, and transparency in those systems, because those systems will have a huge impact because we will start to rely on them. There's no doubt about that. And so this organization that you're in today and organizations for mediators around the world should be very, very, very vocal about what we're going to hold the developers to in terms of standards. And so I'm going to stop there, and hopefully we'll have a chance to dialogue a bit later on. But that's my 2 cents worth in terms of where we've come from and where I think we're going with artificial intelligence and online dispute resolution.
Daniel, thank you so much for what has been a very comprehensive overview of the origins of online dispute resolution. And while that overview is important, today and today's generation, the next generation, everybody is a digital native. They've grown up with the internet. It's not something that you need to be introduced to. So when you call a number, you're not speaking to an operator asking to get connected. You're pressing an IVR numpad, and the only thing that you know for certain is that there will be a wait time. In contrast, suppose you got the wrong food delivery, you have a little chatbot you will talk to, and generally, you're pretty satisfied with that resolution. This is technology at play. One works quite well, the other doesn't. The central tenet here is trust and credibility. You have faith in one, not so much in the other. So the question I have right now is, in today's day and age, where the internet is not a new phenomenon, online dispute resolution is a fact, it's established. What role do we have to take in terms of establishing trust and credibility for the introduction of artificial intelligence? Is the same approach that worked 20 years ago something that can be repeated now, or is there a difference in approaching this? Chitu ma'am, over to you.
Good evening, everyone. First of all, I think, can I have the slides up, please? Yeah, while they're getting the slides up, it took us about 20, the next slide, please, next slide. Yeah, Dan spoke about the origins of online dispute resolution, which started 20 years ago, more than 20 years ago. And when we started it for e-commerce disputes. Now, the birthplace for online dispute resolution is what you see there, which is NCTDR, which is the National Center for Technology and Dispute Resolution. The father of online dispute resolution is Ethan Cash, who created NCTDR and brought in all fellows all around the world to contribute to the field of online dispute resolution. Now, when we started, we had nothing. People did not believe us. And, it took us nearly 15 years to make a case for online dispute resolution and to get it out there to say, yes, it does exist. Yeah, we accept you. And that's how it started. And slowly, it started picking up. And in 2017, we realized that Yeah, we are here to stay. Nobody is going to put us down. We've actually revolutionized the field. We made a case for online dispute resolution, and we needed some sort of a governance for online dispute resolution, and that's when we started ICODA, the International Council for Online Dispute Resolution, to actually, bring in more people into the field, because there were a lot of people, and to educate, to be a home for where you would need information about online dispute resolution. And of course, the pandemic happened, and then ODR is everywhere right now, right? I don't have to explain what online dispute resolution is. I don't have to make a case. Justice Mushtaq now wonderfully actually made the case for all of us to say that, yes, the promise of online dispute resolution, why we need to adopt it, and why we need to include technology into our, resolution practices. Now, today, I'm asked to speak about online dispute resolution and artificial intelligence. I'm just going to go about with a brief, and since we are talking about mediation, I would not go more into platforms and ODR as such, but just a few things. Now, this is where we are now. We have, this says it all. We are too tired to argue. Let's ask Siri and Alexa to handle this for us. This is where we are, right? So Siri and Alexa is handling arguments for us. They will be the mediators for us. That's where we are with artificial intelligence. Now, you see artificial intelligence on, I think, towards your left, and there's a human on your right. What does artificial intelligence do? It discovers inefficiencies, but it also said the bad news is you, right? Humans, we are inefficient, and that's why we have artificial intelligence. And this is the scenario. So if you look at this, Mr. President, I don't know how many of you could see this. It says, Mr. President, would you like to install a new Supreme Court justice or just upgrade the existing one? That's where we are. We're not even having a human there, right? We're just going to upgrade. This is where we are. And this is not a joke. This is reality. We are in this field right now. This is the reality, right? So, what are the artificial intelligence elements? We have computing power, algorithmic innovation, data structures. Algorithms can think analogical, but they cannot reason. Okay, let's just put that into our minds. Patterns, predictive outcomes, right? Artificial intelligence is all of this. Now I'm going to talk about mediation elements, right? I've just put it into two sections: compatible, non-compatible. What are the mediation elements we think about a lot? Issues, problem finding, exploring options, empathy, reframing, reality testing. All this is very important for us. Also the important ones are interest-based, unpredictable outcomes, human emotions, cultural differences, right? So if you look at, according to, what can be classified where artificial intelligence can help us, it's on the left-hand side, and what it cannot as yet help us, and thank God for that, is on the right-hand side, right? So we have that. Now, so I'm just going to talk a little bit about AI compatibility. So if you look at AI systems can learn to mimic decisions made by humans. We all know that. Then it can match future decisions as closely as possible to decisions previously made by an arbitrator and mediator. So, your decisions or the outcomes, it can match. It can match. It can look at information about a dispute and suggest that resolutions can include a set of characteristics like an apology. That's extremely important because in mediation, we all know apology is one of the most important things. So, it can tell us that. AI can do reality testing. I've tried some of it on ChatGPT. So to find out what is desired by the parties. And it can also provide your BATNA. We all want BATNA, so it can provide alternatives to proposals. And big data can provide helpful benchmarks against which to test tentative resolutions. And the most important thing, it can be a very good assistant to you, right? So that is where it's compatible. Now, non-compatible, as I said, you know, interest-based outcomes. In mediation, we all look at interest-based outcomes, right? So when you're talking about interest-based outcomes, as I said, it always matches, right? It's looking for something. But it is, you know, interest-based outcomes is very difficult for AI to really, you know, come up with interest-based outcomes. And justice. So if you look at artificial intelligence, it's also a lot of data. It needs metrics. So where is that justice or mediated outcome? At least in justice, I think we look at, you know, for judgments, we look at precedents and all of that, right? We can put in. But mediated outcomes, right? Can we put that in? Not yet. And softwares can mimic the outward appearance of analysis and emotional engagement, but it does not have sentiments and sensations that drive those processes and give them meaning, right? So it can really not figure out certain things which are there in a dispute, and each domain will need a different set of models. So artificial intelligence, if you look at it, let's say if there's a family dispute, let's say that there is a real estate dispute, you know, we need different data, different models to train that. So you will need, you know, different set of models. And last but not the least, humans think like humans, but AI thinks like computers. Now, we all are talking about generative AI now. ChatGPT is the biggest buzzword. All of us know ChatGPT. We all talk about ChatGPT. We all are using ChatGPT right now. So since we are doing that, what is it that we should keep in mind as mediators when we are mediating disputes and when we are using a tool like ChatGPT or Bard, okay, or any of those generative AI systems or tools which are out there? What is it that we should keep in mind? First is AI bias. Now, AI bias, we all say that, you know, artificial intelligence can be biased, but that can be also be positive, because if it is biased, it will allow you to think, okay, oh, that is biased and let me move away from it, right? So let us always be cognizant that AI is biased. So, and it is biased because people are feeding it with data. So, you know, I wouldn't actually blame the computers here. I would blame the humans who are biased in feeding it with data. And humans need to exercise care and cannot solely depend on generative AI. So whatever output you have or you get from a ChatGPT or a generative AI, you should decide. You know, you should decide whether that's right or wrong. Do I want to really use it? It can be a good conversational partner, especially if you've used a ChatGPT. You can see that it's very nice, very sweet, lovely words, very persuasive, and you know, it's very nice to use it. But beware, right? Too good is not too good. So fact-checked and fine-tune the information, but it can be a good conversational partner. And the most important thing in mediation is confidentiality. So when you're talking about confidentiality, what we tend to do when we use any tool, copy, paste, put it in out there. Let's say that you're using anything in your mediation and you copy and paste it. Can you do it? No. So that's a biggest no. We cannot put confidential information into any of these systems. Please be aware of that. Now, this is a question. In a hybrid model, I would suggest a hybrid model. And in mediation, can you be 100% sure that a case will be resolved in one way? And when I say hybrid model, it's for AI, right? I'm using it for AI specifically over here. The question is, you know, can you be 100% sure that a case will be resolved in one way? No, you cannot be sure, right? And because you cannot be sure, you know, you just cannot use AI over there to just say, okay, you know, now generate an outcome for mediation. That is not possible. Now, ODR softwares, we all know, they do a better job of, organizing information, collecting information, guiding you through the process, transparency, trust. So many things are there in ODR processes. So we should use a tool of ODR. Then we can use tools of AI plugged into it to actually assist us. And we should also be able to identify decisions that may not be suitable to delegate to AI. Not everything can go to AI, so we should actually be aware of it and say, okay, this is not suitable for AI. So in conclusion, I would say that AI is a tool. The choice about how it gets deployed is ours. Don't blindly follow it. Don't blindly go about it. It is a good assistance. AI is actually IA, which is an intelligent assistant. Use it as an assistant, but the choice is ours. The choice is, how do we use it? And, the other thing is, in mediation itself, we just want disputants to understand what they want. Right? So these tools can really help them decide what they want, or, to actually clarify their thoughts. So let's use it for that purpose. And for people who are building ODR systems, like Namita, like myself, we have to be aware of these ethical principles of online dispute resolution, which actually, Dan came up with this with Leah. And these are the principles of ODR which are available on icoder.org. So when we are developing ODR systems, we follow this. When we are ODR practitioners, so let's say mediators who are online, we practice this. Now for AI, we need to practice all of this, right? These are the principles, ethical principles, which will apply. And when we are building AI or integrating AI tools into our ODR systems, or when we are using it, this is something we need to be aware of. Thanks everybody.
Thank you so much, Chitu ma'am. We can clearly see the possibilities that AI has for us, and especially where we are. It's hard to imagine that we would have an assistant like this to take us further in understanding what we're looking for, to understand what we need, what we want, identify our interests. And at this point, I would also say it is very much in your interest, dear audience, if you have any questions at this point regarding the fundamentals of online dispute resolution and artificial intelligence, how they operate, please feel free to raise your hand and give us a go. Yes.
Madam, I think you have touched upon, but I am not clear about how confidentiality can be maintained while using online mediation systems. Second thing is, if we want to practice online mediation or AI into our fold, what are the websites or what are the where we can find it? Can you give some clues about?
Sure. I think confidentiality, Namita is going to touch upon confidentiality, so I'll let her speak on confidentiality. And, for AI, you do have, material. Even if you look at, there are materials which are posted in odr.info, where we talk a lot about, artificial intelligence and how it can be used in the practice of mediation. And there are a lot of webinars we've run. There was a conference right now with mediate.com also, where you have a lot of information. So I would highly recommend, mediators to look at that. Mediate.com has also got lovely material on that. Thank you.
Kindly share this PPT to us. Thank you.
Sure.
It's copyrighted, sir. I just wanted to share a perspective on this, because you put this AI compatible, and that one of the things was empathy that you mentioned. Oh, you wanted the same question. Now, empathy is something that I'm unable to fathom, because yes, a machine can look at me and tell me that, Jawad, look, you're feeling sad and you look very depressed or whatever. But the machine cannot feel what I'm feeling.
Correct.
Whereas when I have a human mediator, I feel more comfortable sharing my emotions with the human mediator simply because I know that that person is capable of feeling what I'm feeling.
True, true.
Right?
So I had,
Yeah.
let me just tell you, I have human emotions on my right and I have empathy on my left.
Yes, yes. I
Right?
saw that. I
Right.
noticed that. Yes, absolutely. Yeah.
So you can get empathy out of certain generative AIs
Yeah.
when you key in certain things. If you look at it, online counseling also is happening.
Yes,
right?
that's right, yes.
Because it can talk to you.
Yeah,
I was talking to a youngster just 2 days ago,
Yeah.
and I was like, hey, there is this, and would you like to do it online? It was a dispute or not. And she just said, I want it online.
Yeah.
I feel more safe online. There's no judgment online.
Exactly.
And I like what the computer tells me.
Well,
So
that's very interesting, because being non-judgmental, a machine
Yes.
is non-judgmental. So
Correct.
I feel more comfortable sharing a lot of information.
Yes, and I
with
think
the
the
machine.
youngsters
Yeah.
are going that way.
Yeah,
If you look at all of them, the millennials,
yeah,
they don't want to talk to humans.
yeah.
Okay, they feel very comfortable talking to a computer, or that's how they communicate. So the older generation, we are still with humans, but the youngsters are moving away from that.
But don't you think that's a little bit, very dangerous? I mean,
It is.
It is quite dangerous.
It is. So if you look at what's the talk in AI right now, even the person who invented open AIs, he's saying that humans are at the brink of extinction because of AI.
Yeah.
So you have a lot of dangers,
Yes.
and they are coming up with a lot of regulations currently.
Yeah.
They are actually having a meeting currently right now. I think Rishi Sunak just announced today that he wants an AI watchdog just for this. But unfortunately, we've gone into the war zone right now.
Yeah. No, because I keep always consoling myself by telling myself that, look, as long as I cannot take Alexa or Siri on a date, I'm okay with AI being there, right? So
But they are taking now robots on dates.
I know. So robots are going on
Yeah.
dates. So hopefully we are. I don't expect to be to be alive by that time. I hope I'm not alive by that time. But yes. Exactly, sir. Yeah. Yes. Yeah. Yeah. Yeah, yeah. Yes, yes.
So the empathy is a factor. In metaverse, it's a different.
It's different.
So metaverse, many of us still to experiment, and
Yeah.
I think in metaverse will take care of many feelings related to human. That's what I believe.
No, but that's what is very
your avatar
dangerous,
start
actually,
feeling that
because
you feel that you are in this ambience. You feel that you are in the drive somewhere other places, Marine Drive or Marina Beach. You feel that you are in AP High Court or Telangana High Court. Similar way, you feel that the feeling can be created in metaverse.
See,
In
because,
metaverse, there may little more other dimension apart from things speaking of. Yeah, apart from speaking about
holograms are there.
AI,
Yeah.
that feeling, maybe the settings of mediation can have different dimensions.
Yes.
But we need to talk a lot about later in some other stage.
I mean, the
think
future
metaverse
is
can
quite
create a lot of-
scary, actually, if you look at it.
Metaverse
that
can.
way.
Metaverse can.
Vivek is saying no, it's not scary. But in fact, for a very long time, I didn't understand what is the metaverse. And I asked my 14-year-old grandson, I said, can you explain to me what is the metaverse? And he took me through it, and he helped me to understand what exactly it is. So, I mean, I don't know. For me, for a person like me who is about 61 years old, it's quite, unimaginable that I'll have so many different avatars. I'll feel like a split personality, multiple personality disorder or
If
something.
the US lady can feel she has been groped, you can also feel
Exactly.
I think, Your Honor, you were talking about augmented reality, which is pretty much this metaverse. Today, it's very much a part of it in games like Pokemon, everything else. So being a part of the Telangana High Court, all this is very much possible. And Jawad, for you, you can't take Alexa on a date, but she can send you on one.
You're present in that. You'll feel almost physically you're present in that.
Exactly.
Though you're virtual world, but you're feeling that you're in a physical mode.
I think this is particularly interesting that we've taken up the example of feeling like we're in different high courts. Because more than anything else, these are regulatory bodies. They create laws, rules, procedures, and make sure that they're enforced. And I think that's an important topic of discussion when we're talking about AI and its many, many possibilities. So I'd now like...
Can be another topic.
Indeed, it can be another topic, and we have two very different experts from different areas here. So this question is really open to both you, Namita first, and then Vivek. How do we go about regulating online dispute resolution in AI, especially in India where, for example, we have a right to privacy right now, but we don't have it codified? There's a data protection bill that's been sent back twice over. Within this regulatory environment, how do you sustain an online dispute resolution platform from the legal perspective? And, you know, in terms of compliances, Vivek, what do you do in terms of artificial intelligence and making sure that it's playing fair with everyone? Namita, over to you first.
Thank you, Romit, for that question. I think I've been asked that for the past 6 years. So just a few thoughts around that. Firstly, let's talk about a difference or a dispute, you know, before we get into confidentiality and data privacy and online. That happens because something that was agreed upon went differently, either agreed explicitly or implicitly. But when it comes to resolution of these kind of differences, it suddenly becomes about the law, about the processes, and about the complexities involved in it. A dispute that happened between two people suddenly became about the law when you resolve it using existing proceedings. And that's where I think mediation holds a solution, because it does two things very effectively. Firstly, it gives the power back to the disputing parties to decide upon what's next to come and to decide upon the outcome. And secondly, it gives the power back to the disputing parties to decide how to reach there. But when mediation can do all of these things, how do we really make it accessible? How do we actually make it in a way that today every single citizen in the country can actually go ahead and resolve their disputes? I think the answer definitely lies in technology and in the online world. And the mediation bill from a regulatory perspective also does recognize how online holds key to actually make mediation scalable, so that tomorrow we don't have 5 crore pending mediation cases. The mediation bill and its objective, amongst many others, is to actually recognize online mediation as an acceptable and cost-effective tool to resolve disputes. But whenever we hear the word online, automatically our alert antennas go up. And we think about, what about security? What about confidentiality? Somebody is going to steal my data. Somebody is going to hack into me, into my online world. What then? But let me ask all of you here one question. How many people here have actually used any online form of payment? You know, be it net banking, be it credit cards, debit cards, be it UPIs. I'm sure all of us here have. But did you know that in the past few years, there have been acknowledged successful 248 cyber attacks on the Indian banking system? And over tens of millions of credit and debit card details are available online at the click of a button. But before we transact online, we don't think about this. Before we actually transfer a few hundred rupees, or before we buy anything online or pay some fees online, pay court fees online, that thought doesn't come in our mind. Then why do we hold ODR in different light? Why do we suddenly get all bogged down when it comes to using the same technologies to actually resolve disputes? You know, I acknowledge that no online system can be 100% secure, and that's a given. But no system in the world is 100% secure. So when you're using those systems, why not use it for ODR as well? Today, no road is free from accidents, but we still cross them, we still use the roads because of the convenience it brings, because of the benefits it brings. And that's the biggest card that online mediation holds. It actually makes it effective and accessible, which today is one of the major challenges in India. But let's acknowledge the risk and talk about it. You know, we think that, as Sir also asked, what about confidentiality in any online proceedings? Now, let's say the mediation was happening in person and I walk in just like this. Nobody will question me, nor will the mediator or the other party think that I'm doing something wrong. But let me show you what I have in my pocket. If everyone can see, this is a pen. Half of the body of the pen is actually transparent, and the upper half has a white coating. It's a normal pen. But this is actually a recording device. And the blue thing that you can see inside records it, and the white part here stores that particular recording. If I can bring this in a physical mediation, I can also record it in an online mediation. The risk is actually equal. It exists as much in the online world as it also existed in the physical world. It's just that when it comes to online mediations, we feel resistant towards it. The risk is based on intent of the party and not necessarily the tool that is used. But the mediation bill also takes care of circumstances like this. Specifically section 23, 24, 78 to name a few. They say that any recording, whether it be of any negotiation, offers, counter offers, anything that was said in a mediation proceedings, cannot be produced before any tribunal, any court, or any adjudicatory body. And that itself shows that even there has been regulatory backing for aspects like confidentiality, especially when you deal with disputes online. But here I'd also like to point out one more thing. Is it only the regulatory body's responsibility, or is it also our responsibility to secure our online activity? It's like saying that if you leave your door unlocked and a thief comes in, can you blame the builder? Or do you blame yourself for keeping your house open and inviting thieves in? It's the same thing. We think the responsibility does not lie on us to secure our online activity. It equally lies on us. And all we need to do is use a secure Wi-Fi connection and use some antivirus on our laptops. But we don't do those things and then we blame technology and tools. The point is that risk exists in all systems, whether it's physical or whether it's online. It's about how we take measures to the best possible extent to protect ourselves. And just like we would do in in-person proceedings, it's just that the type of mitigation is different. We still are then equal when it comes to risk, when it comes to doing mediations online. But then some may still think, is India really ready for online mediation or for online dispute resolution? Let me tell you one thing. As on February 2023, India had the highest data usage per user in the world, standing at 19.5 GBs per month per user. And what is more surprising is that as on April 2023, almost 100% of the connections in India were either 4G or 5G enabled. So when we think that, India means 2G and 3G and, there are issues in technology, that is changing and changing very, very rapidly. This also means that it can be leveraged to help parties resolve their disputes right from the comforts of their...
Who has the blinders on the eyes, right? So the way I see it is, AI should not be, let to do whatever it is supposed to do. We should be telling them what it should do rather than asking them what you can do, right? So that's important for us. If we could do that, definitely that can help any field, whether it's banking, healthcare, legal, or justice, or whatever we may want to say. Now, the second question which was asked to me was, agar AI ye karega to hum kya karenge? Right? This was another question which was asked in the Delhi conference. And the same question was asked by 3 different personas: judges, lawyers, and the students, all 3 of them. My answer was very simple. Elevate yourself. AI ke saath kaam karna seekho, otherwise you are not going to survive. So AI in any system is not going to replace anyone. It's just going to assist you in doing things in a better way. That's my view of doing. I know Chetu ma'am spoke a lot about what it can do, what it cannot do, so I'm not going into those details. Basically, we need to use AI to help us. So, we are building a product. Wonderbots is building a product called Justice Bot, which aims to do certain things with certain different individuals. So, like, if I take an example for a lawyer or for a mediator who does the drafting and all, the product can help you draft, right? Now, nothing new in that. Everyone does that. Every other tool does that. What is the value add then? Why the different tool? Why do we want to, why you would like to buy my product, right? So how awesome it would be if, let's say, you are drafting a document for a divorce case in Noida. There may be separate set of documents which are required. And in Delhi, there may be separate documents. In Bangalore, separate documents. So the moment you say your marriage was registered in Bangalore, you need these 10 documents. And in all 10 documents, the information is the same. Just the header changes, the footer changes, and the signatory changes. So why should a legal assistant or mediator or lawyer, whoever that person is, why should they write it 10 times? Why not put it one place and the rest of the documents get generated automatically? That's one use case which would compel you to buy my product if it comes to life. Now, the other question which was asked to me, what else can it do? Of course, it can do research for you. It can find citations for you. It can find any information that you're looking at. Now, people speak about ChatGPT and confidentiality. ChatGPT 3.5, which you are using online, OpenAI something / ChatGPT. It says whatever you write in there, it is going to use it to train its own data. No one asks a question on that. In India, people go to market, apna mobile number deke, they take a toffee and come back. No one talks about confidentiality there, right? You go to any insurance agency, you might have gotten that call, right? Sir, come with your wife to our hotel. We have free this, free that. Just come and we will not say anything. You just take free and go. Do they give you free? They sell your data to people like me, who will sell you again some product which I may have. I mean, confidentiality is a myth in India, at least. That's what I would say. People talk about confidentiality when it is for their benefit. When it's for free, they don't talk about confidentiality. Aadhaar card, when the government made it mandated, there was a lot of hue and cry, right? Aadhaar will steal our private properties and it will sell. I mean, no point in talking about it, right? It's us who need to control what we are going to do. I mean, there were times when humans were learning about the computer language like C, C++ and others. Now the computer is able to understand our language and speak in our language. That's the power they have. And we need to put it in the right direction. That's all. Applications can be endless. We can use AI the way we want. We will use AI till the extent it helps us. Do not have the decision-making capability with the AI. That's what I would personally like to ensure. And that's what I would urge anyone who is working in this field to ensure that we don't lose relevance as a human being. Thank you, everyone.
Thank you so much, Vivek. I mean, it's of course important to see how artificial intelligence as a tool can aid you, assist you, reduce inefficiencies. So much drafting. I don't think any of us as lawyers are really fond of doing pages after pages after pages. And I'm certain that the clients are not, because of course we bill by the hour. For mediators, we bill per session. So we always need to keep the end user in mind when looking at what the impact of artificial intelligence and online dispute resolution can be. And keeping that in mind, we'd like to turn to our last speaker for the day, Ms. Anna Sambold. Anna, as a practicing mediator, what are the effects of online dispute resolution that you've seen with clients that you interact with regularly? Has there been any artificial intelligence or any AI-based tools that you've used in mediation that you found to be effective? Over to you, Anna. Thank you.
Good morning, everyone. I would like to share my screen. Is that possible?
Yeah, we're getting on it. Just a sec. Yeah, Anna, just try. We've enabled it from our end. Lovely. Okay, we can see it. Thank you.
Wonderful. Let me just get, okay. Well, good morning, everyone. Delighted to be here today to talk to you about practical applications of artificial intelligence and ChatGPT. This is one of the topics that is just fascinating to me. And that's what I'm here at 4:40 in the morning, awake, participating all the way from California. And with the with the help of AI and chat, I was able to put this technology and this presentation
Anna,
together.
can you hear me?
Yes?
I'm so sorry, I don't think your computer's woken up just as well as you have. Up on the first slide.
Do you see my screen? Do you see my computer screen?
We see your screen, but it's frozen with the audience window saying enter full screen mode.
Okay, so let me see. Okay, let me try it again. Enter full screen. Share.
Okay, I think we're good to go. Do you want to quickly change the slide and see if that works?
Yeah, let me check.
Okay, lovely, fantastic. All good.
Beautiful. Okay, so let me. Well, but before we start with talking about all the practical benefits of using artificial intelligence and AI and ChatGPT, I wanted to talk about what exactly is artificial intelligence, because I believe everybody talks about it, but it is a concept that is not really clear to all of us. So this is what the easiest and simpler explanation that I can find with the help of chat. When I ask him, what exactly is artificial intelligence? Please explain to me in a way that is easy to understand for everyone. So chat provided this great definition. It's basically a broad field that involves the development of computer systems. And these computers can reason, can learn, can make decisions and perform different tasks, doesn't matter what. Nowadays, we have different types of computer systems, and chat is one of them. ChatGPT is the best and the most well-known of these computer systems that it is trained with to learn patterns, to understand and process information and respond to human language and have conversation with people. So it is the most well-known on all these computer systems, but there are other ones like Bard from Google, like Bing AI from Microsoft, or Llama from Meta. But since ChatGPT is the easiest to work with, and right now it is still free to use, I guess that's what ChatGPT is becoming the most popular one. So what are the ways that we as mediators can use ChatGPT and use it in our everyday mediations? Well, since I have limited time and I have, I believe, 15 minutes today, I come out with 10 ways that we can use ChatGPT as a mediator. But before I go into the practical applications and uses of ChatGPT, I want you to be aware of the capabilities and limitations of ChatGPT. First of all, in capabilities, Remember, like the previous speaker was mentioning, ChatGPT, any information, any question that you ask Chat, the machine will remember, and it will remember and it will save all that data. That's how the computer system works. It's trained with all that data that you provide, and that's how it provides information and engage, provides and generate responses. It's always it's always good to be aware too about the limitations. And may occasionally provide incorrect information and responses to your questions. It was in the news last week, this case where a lawyer cited a bunch of cases, for example, and in his case, the opposing counsel find out that these cases didn't exist. So he complained to the judge. And the judge asked this lawyer, where did you come up with all these cases, for example? And the lawyer had to admit that he asked ChatGPT to write his brief and provided all those cases. And that was the first time that the lawyer was using ChatGPT to draft his brief. And he trusted ChatGPT, but what happened was that all those cases were non-existent. So basically, ChatGPT provided inaccurate information. So you have to be aware of that it can provide a lot of information, but sometimes it cannot be accurate. Also, you had to be aware that ChatGPT is limited to provide information until 2020, because after 2021, the system doesn't have any information. So it will provide information, but is limited knowledge of the world and events after 2021, he won't be able to provide any information. So with that, let's go and talk about the first use of how the first practical applications that you as a mediator can give to ChatGPT. Well, the most obvious one is ChatGPT can provide access to a wealth of knowledge and information and resources. And it's just unbelievable that by just typing a question into ChatGPT about anything, you can pretty much have in 3 seconds access to all this information. And let me give you an example here. I asked ChatGPT, for example, what are the key provisions of the Electronic Fund Transfer Act? And in 3 seconds, basically, it provided me a good summary with the QR code, and you can connect it with the method, and I'll be happy to answer any questions that you may have for me today.
That was wonderful, Anna. Thank you so much for what has been an incredible PowerPoint for all of us to watch. And I hope that all of us will now wholeheartedly embrace our friend chat. With that, I think we're done with all our panelists for the day, so the floor is open for any questions for any of the panelists from our dear audience. Over to the audience. Thank you. You know, no questions? I think, Anna, you've left them all with too much food for thought at this point.
Okay, well, it was a pleasure to be here today. Now I'm going back to sleep. It's 5 in the morning, Sunday, and it was a pleasure. I hope the next time I can join you in person.
Thank you so much, Anna. Please enjoy your Sunday. Bye-bye.
No closing remarks because everybody's in a hurry. Myself and ChatGPT can't hold my flight back, so I rushed home.
I request all the panelists and the Honorable Chairperson onto the dais. Anyway, I am delighted to share that differences, disagreements are the source of evolution of man. And his intelligence in a very natural way. When evolution geared to revolution, disputes becoming obstacles for growth and hence resolution became answer, and due to revolution we replaced our intelligence with artificial intelligence. This evolution of resolution spread out its wings into the field of ODR and artificial intelligence, bring revolution back into life, pushing us forward. All our endeavor is not to see that there is no dispute, but to say life is beautiful, enjoy it. So all the day long, we touched all the aspects of resolution, online, resolution to online resolution, mediation to artificial intelligence. And it is my privilege to represent all the coordinators from the India and abroad in presenting love and affection to Honorable Justice A. Muhammad Mustaq, Judge, High Court of Kerala, the God's own country. I heartfully welcome Sachin Jain from the coordinator from state of Punjab and Haryana to honor the chairperson, Justice A. Muhammad Mustaq ji, who delivered the keynote address. Very glad, sir. I take this opportunity. Thank you, Jane. I take this opportunity to applaud our very smart moderator of the panel discussion, Mr. Romit Sarkar, Associate Counsel of International Arbitration and Mediation Center, Hyderabad, for his effective role in bringing out pearls of wisdom from our panelists. I express my gratitude to all the panelists to share their experience and wisdom in nurturing the minds of our mediators. I request who is the person? I request Anup Kumar Srivatsav from UP to felicitate our moderator. I express our gratitude to our panelists who cared to share their experience and wisdom, nurturing the minds of mediators, and Chitu Nagarajan. She already left, and we honored her with the memento. And I invite, on behalf of the mediators present here and present through the online, every point has 360 degrees. The perspective changes by the angle, by every angle. Mrs. Namita Shah, the co-founder of Presolve 360, gave a valuable inputs on this AI. I request Beena Shah Soni from Delhi to honor our panelist Namita Shah. On behalf of our EMW and Litigators Prime, Hyderabad. We are honoring with memento and our love for her. Wonder is always the first step for great quest. If Vivek is there, wonder boats always sail wonderfully. The panelist Vivek Goel, country head, wonder boats has made our boats to move ahead. I welcome Sandeep Saxena, the state coordinator of Uttar Pradesh, to honor our panelist Vivek Goel with a memento on behalf of EMW and the Litigators Prime. He gave a nice explanation and meaning. AI, is it absence of intelligence or artificial intelligence? On behalf of all the moderators, on behalf of all the mediators, delegates, and throughout the country here, I extend thanks to Mr. Daniel Raine, author, editor, International Journal for ODR, board member, ICODR, and co-chair with Anna Maria Goncalves for IMI ODR Task Force. And Mrs. Anna Sambold, Chair-elect ABA Dispute Resolution Section, United States, who imparted technical information and sensitized on AI and Chat GPT. I request our camera person to focus on our mediators and delegates, students, extending applause to all the panelists as a token of honor, because that is the only thing we can. I request the cameraman to focus on all audience to give applause. This is honoring our panelists online. Yes. Thank you so much. So the conclusion of our last minute is, let connect. And let us connect and reconnect, but never replace. Yes, I thank you so much. And next program is valedictory function with the many takeaways to our home bag, tons of wisdom and new perspectives. Thanks to EMW and Litigators Prime for giving me this opportunity. I thank you one and all. Thank you so much.
Dear all, we will commence the valedictory ceremony in another 5 minutes once we are rejoined by Manjeera ma'am. Thank you.
Good evening, one and all. There is a strength in number, same way a stick in bundle is unbreakable. United we stand, divided we fall. I am referring to my EMW team. It is not a team, more than a family. So I want all the team members to stand up and just to show who are our EMW members. So this is a bundle of sticks which are unbreakable. So again I am repeating the words. United we stand, divided we fall. I am referring to my EMW family. So I invite Honorable Justice Kalyan Rai Surana, Judge of Guwahati High Court. Sir, kindly come on the stage. Before giving the mementos to our family members, just since morning, our journalist, like ETV chief producer, ETV Telangana and Andhra, since morning, spending his lot of time and waiting for us to receive the memento. Pushp, just as you also should be there for, yeah. ETV has. Huh? Justice Menon sir, come on the stage, sir. Pushpa Gupta. Uma ma'am, Jawad sir, and Chitra ma'am, please come on the dais. Power of mediation. Today we had a very good coverage of TVs and all that, because for that I am thankful to the Sharma sir, who is the backbone of today's total program. Hope we are also be same as you are till 73, hale and healthy. 74. Now the memento to our Amarneni Harikrishna sir, ETV chief producer. Sir, Randi sir. Rajendra Menon sir, maybe. I wish everyone will give him the award because he covered our program. Sharma sir, Chitra ma'am. Thanks a lot, Harikrishna sir. In your busy schedule, you have spent whole day with us. Now our mementos for our EMW family. Reema Bandari, Miss Reema Bandari. Coordinator of Delhi. Yeah. Mrs. So, Honorable Justice Kalyan Rai Surana, Judge, may give her the... Honorable Judge Kalyan Rai Surana, sir. Next, Kavita Bhatia, Coordinator of Gujarat. Kavita Bhatia, please come on the dais.
I think we can ask all our dignitaries to stand so that they're getting up and they're sitting.
Sir. Justice Kalyan Rai Surana, sir, please.
Should I go and stand there to help them with the mementos?
Next, our coordinator is Mr. Suresh PG, Coordinator, Kerala. Uma ma'am, please. Mr. Srilal Warrior, sir, Coordinator, Kerala. Kerala State. Left, huh? Okay. Arvind Kurani, Mr. Arvind Kurania, Coordinator, Haryana. Jawad, sir, please.
And it's his birthday also, so wish him happy birthday. No, on my.
For everyone it's there.
No, but Deepak said when you're announcing, wish him happy birthday also. It's his birthday, it's not birthday.
Mr. Deepak Seth, Coordinator, Haryana.
And it's his birthday also. Deepak ji's birthday. It's Deepak Seth's birthday also, so our good wishes to him for a bright year ahead. Happy birthday, Deepak ji.
Mrs. V. Usha, Coordinator, Pondicherry. Chitra ma'am. Next. Next, Mr. Adani Kamo from Manipur. Thank you, sir. You came from Manipur. Yeah, Sharma sir. Sharma sir, may. Mr. Sandeep Saxena, UP. Justice Rajendra Menon, sir. Mr. Anup Kumar Srivastav, Coordinator UP. Justice Kalyan Rai Surana, sir. Mrs. Revati Ganesh Mohan, Coordinator Tamil Nadu. Justice Kalyan Rai Surana, sir. Mrs. Neena Kare, Coordinator Madhya Pradesh. Jawad, sir. Mr. Hari Krishna, Coordinator Andhra Pradesh. Kalyan Rai Surana, sir.
I am not complete without Srilata, so
Yeah.
Chitti may also be on stage, please.
Chitti, please come on the stage.
Sir, ma'am is right now the chairman, presiding officer, State Consumer Forum, President, Andhra.
Mr. Rajesh Kumar Batra, Coordinator, Assam. Rajendra Menon, sir, come, Kalyan Rai Surana, sir, both of you. Mrs. Pramila Acharya, Coordinator, Rajasthan. Mrs. Lata Prasad, Coordinator, Karnataka.
Prasad ma'am. Lata Prasad ma'am. Lata Prasad ma'am. Lata Prasad, she's coming.
Mrs. Lata Prasad, Coordinator, Karnataka.
Yes, in appreciation awards. No? Appreciation awards. No, what about those appreciation awards for these other people? Praveen and all. Did you not make for them? You call me, no? Praveena, then Asha, Ruchi, Suhana. Appreciation awards.
So now I would take the honor to call all my dear friends from Delhi. Appreciation awards for them. Khaliya thodi bhejna hai. So Praveena Gautam, we'll start with Praveena. Praveena Gautam. बिल्कुल नहीं भेजना है. This is the beauty of EMW, na? So, I will request Menon sir. Oh my God, I'm so sorry. तो मेरी गलती नहीं है. Sorry. सचिन को तो बुलाया. अभी he is the boss, the last में. Sorry. So, okay. So I would now request Mr. Sachin Jain, our coordinator from Chandigarh, and by mistake, we deliberately We deliberately did a mistake. इसमें नाम लिखा हुआ है क्या किसी का? I was thinking जवाहर सर की wife should be on it. I would now request Binasha Soni to come on the stage. We can then give one. ठीक है. इनके बाद को बुला लेते हैं. We have one extra. I would now request Miss Ruchi Khurana. So they are our friends from Delhi and are definitely part of EMW. And without them, you know, हम लोग 2 दिन से जो enjoy कर रहे हैं, shopping कर रहे हैं, can't do without them. We are again going to give.
And I must mention for Ruchi Khurana, sir, she is working day in and out for our 365 days mediation quotation calendar from EMW. So yeah, and soon we'll release that also. Thanks to you, Ruchi.
अच्छा सुनील भी तो चली गई. So I would now request Archana Malik. And ye?
Yashna is also.
Oh, okay. So. हाँ इतनी एक्स्ट्रा बची है ना. ठीक है तो मैं उनको हाँ.
No, they have left. They have left. They have left.
Beautiful dupattas, definitely. And I just want to take an opportunity to bring Anis on the stage now. And the award should be given by Jawad sir, I think. ऐसे ही मजे के लिए.
It's a rare sight.
Rare sight. सर आप भी साथ में रहिए फिर मजा तो उसी में आएगा. घन सर पिक्चर. और कौन रह गया? वो तो क्या कर
बेटा है ये लिटिगेटर्स टीम है. Special thanks to Anuji for joining. It takes a village to make an event of this magnitude a success. Thanks to our non-EMW colleagues who worked equally hard. Now coming to the litigators team. First, none other than our NB Subramaniam. I request all of them, like he deserves that his memento should be given by everyone.
I want to say something about Subramaniam Subbu. Today's one of the most interesting discussions was on online mediation, ODR and AI. Right from the beginning, he has been insisting that AI should be included, and I was not in favor of that. And I now understand that he was right, no, because that was the most interesting part of the program. Thank you.
Mrs. Manjula Chakravartulu, litigators prime. These all are my litigators prime pillars. I think our litigators prime needs everyone's mementos. Mrs. Padmaja Reddy. Mr. Arun Kumar, my little brother. Now, AMS Law College, Dr. Lakshmi, our principal. Why I said our is, I am also secretary to that law college, Andhra Mahila Sabha, Durgabai Deshmukh. She is a principal to that college since 1991. Where she used to do, like, it was only established in one room, sir. Now it's a different, it went in a different level, our college. Mrs. Tarunam, who is one of the big support for this event. Yes, yes.
I want to say something about Tarunam. Just now, Chitra was asking me, oh, how come you could write the name in every memento? So many mementos have been given, and it is really unbelievable. Generally, what happens is, without the name, people give, when there are so many. And that is the work of Tarunam.
Now our Telangana advocates and my brothers, K. Harimohan Reddy, Mr. Venudar Reddy, Venanda, Randi. Now it's a time for mementos of our two bosses. Miss Pushpa Gupta. Mr. Tankanchan, sir. Mr. K. Sharma, sir. When K. Sharma, sir, associated with a litigators prime, then I ventured for this event. Otherwise, I don't know how I would have done. Thanks a lot for you, sir.
So, Manjira,
Now please give me an opportunity to speak for a minute. So now it's our time to, everybody should stand up, and we are already there. To hats off to this lady Manjira. I can say she is Manka Hira. Her name is Manka Hira, pure soul inside outside. The way she has worked for this conference, it was in January that we decided that let's go out of Delhi, and she was the first one to volunteer that yes, we will have it in Hyderabad, please give it to us. And she has a daughter from USA here for a short stay. Despite that, she is managing. She has Amma at home who is not keeping well, but hats off to her, led by Mr. K.S. Sarma sir and whole brigade from Telangana. They have made this day possible. Thank you so much. Thank you so much, Manjira. We owe this.
For me, sir?
Morning we have done it. Morning session.
Tarunam, some of the other awards which you have to come. The young students who
Next, Sumit Khurana. She's not, okay. Sangeeta Mehrotra. Oh, Yashna Malik.
Same level. Yeah. No vote. Vote. Then after this we'll have group photo.
Yes. No, yeah, you can sit. Don't go. All good things come to an end. This Mediators Parliament come third anniversary celebrations of E-Mediation writings is now coming to an end. But I believe that this end is just a beginning, an opening of an opportunity. Because the speeches and the panel discussions have inspired everyone who attended this program to embrace the mediation as an appropriate way to resolve the dispute. A lot of work has gone into organizing this event. It was a collaborative effort of members the office bearers, and well-wishers of EMW. Let me begin with thanking Ms. Pushpa Gupta and Mr. VP Tankanchan, the top bosses of E-Mediation writing, for reposing faith in me by entrusting me with the pleasant task of hosting this year's anniversary in Hyderabad. The content and delivery plan of this Parliament of Mediators were taken care of by Mr. A.J. Jawad. He has been a guiding light to us in organizing this program. I thank him from the bottom of my heart. Thank you, sir. I ventured into organizing this event because of encouragement, assurance, support that I received from the chairman of Bar Council of Telangana, Mr. A. Narasimha Reddy, sir, and our K. Sharma, sir. I needed hand-holding as I have no experience in organizing such events, which both of them did for me and gave me full support. They guided me from inception of this program to this day. Sharma sir stood as a main pillar for this conference, and he also plays a major role at our litigators prime too. As a token of our gratitude to all those who contributed to the success of this beautiful event, I thank the media and the newspaper for covering today. Special thanks to Mr. Though he left, Mr. Amarneni Harikrishna, who has taken responsibility for news coverage. We are grateful to the management staff of Marigold and event manager Rahul for their cooperation and support. Rahul, you have to stand. You need applause. Without sleep, you are doing. Last but not the least, I thank all the delegates and EMW family for attending from different states and attending the program attentively. Apologies for those whose names I have not mentioned, can forgive me. Once again, I thanks to each and everyone. Namaste. Thank you. And I request all our EMW coordinators to come on the stage for photograph, our family picture. राहुल ये अरेंजमेंट कर दो ना थोड़ा
This is the parliament without opposition.
Raju, call Jayamma. Subbu, Raju, call Jayba. Raju, call Jay. Surana sir about it.